All right, and good morning. Welcome to Making Law Simple. My name is David Helm. I'm a licensed practicing attorney in the state of Michigan. And today we have a special guest, Danielle. Hey, welcome,
Hello.
Danielle.
Hi,
Danielle will
thanks
be
for
joining
having me.
us. Oh, well, thank you for being here.
Yeah.
You've been on a panel before with me, but I don't know if you've streamed a trial together yet.
No, we haven't streamed a trial together, but I've been on a couple of your panels.
Okay, very cool. And so today we have day 2 of James and Jennifer, or rather Jennifer Crumbley murder trial. I'm in the habit of calling it James and Jennifer because they were scheduled to go together for so long until the last minute. But we have Jennifer's manslaughter trial. Day 2 is starting. I wanted to give a brief recap of day 1. There were some interesting things that came out of day 1. I don't know how much you were watching. You said you were watching it yesterday, Danielle?
I replayed some of day 1, but didn't get the full. Yeah.
So I put some clips up of some things. At one point, there was a video played of the shooter. They're not allowed to call him by his name. They have to call him the shooter.
I noticed that. Yeah.
Yeah, I know. I don't know if it's because he's a minor or what, but it's a little annoying. Although I will say that this creepy ass ATF agent, that guy, he called him by his name several times on the stand. He's not supposed to. But doesn't this guy, like, if you saw him walking down the halls of a school after a shooting, isn't he the person that you would suspect?
Oh, absolutely.
It's so creepy looking.
Yeah, so that had to be him.
Yeah. Right. No, he slipped a lot and called them by his first name, which he's not supposed to. But one of the very interesting things, I'm going to play this part clip that I have. This is one of the things. So, if I was to summarize yesterday's testimony, I would see involved parents engaging with their child out in the world in a hobby that he's enjoyed, exercising safe and responsible gun ownership. That's what I saw. And I mean, for the most part, we have the drawing, right? We have this math worksheet drawing that the parents became aware of the morning of. But other than that, everything else is like safe and responsible gun ownership and being an involved parent.
Yeah.
Now, the state had, I'm going to pull this video up. This is a short clip. And by the way, we're just waiting for the feed to go live. And we'll go live as soon as it does. But this is from yesterday. This is the testimony that was presented with the ATF agent who is tracking locations and presenting videos. If you remember, there's a couple of videos that Ethan made of the firearm that he then sent to his friend. And in the text, he said, "Look at what my dad left out," or "I found," or something like that.
Google location information for James Crumbley. And it's dated August 19th, 9/29. It's around the time of the first video of the last 2 that we've seen. And it shows that he's at the Crumbley residence on East Street.
Okay, and the time on that?
It was 9:29 p.m.
Okay, and that's the video of where the couch was in the background.
Correct.
Okay, and then the next exhibit. This is 55. What is this?
This is the Google location information for Jennifer. It also shows that the at East Street address, the Crumbley family residence.
Okay, so in other words, both Jennifer and James were home during the photo with when he was holding the Caltech and there was the couch in the background.
Yes.
Okay, and then 56. This is August 20th. So it's the 12:32 where the video was taken and the text, "My dad left it out."
Yes.
Okay, and this shows what?
This shows that James Crumbley, the Gmail account associated with James Crumbley, was at the East Street family residence, Crumbley family residence.
Okay, at 1:30 in the morning.
At 12.
Okay, so what's interesting about that is when he's taking the pictures, the state's witness, or when Ethan is taking the videos of his firearm saying his dad left him alone with it or didn't properly secure it,
Mhm.
his parents are there in the house with him, which was crossed on substantially. Well, not substantially. It was very difficult to cross this particular witness because he was being a pain in the ass. But it got, I mean, essentially, she was successful in getting out there. I don't know if the parents were there. It's possible that the parents were there and he embellished.
Mhm.
And I have a whole problem with that. I think the state is pushing a narrative that just simply doesn't exist. Hey, uncivil. If you want to join me for a stream this trial, let me know. Could be fun. All right, I'll think about it. I'm covering this trial. I know you're covering this trial. And Sybil was streaming yesterday too.
Oh, he's covering it too. Yeah.
Yeah. Well, you could come over here, Kurt. Come on over. But welcome in the chat. Yeah, we could do an MLS uncivil crossover. There we go. Yeah, so he was home, Jamie. Defendant was home, her husband was home, and the shooter was home when that video was made. And then you have again, all the other videos that they showed were parents going with their son to a shooting range, practicing safe and responsible gun ownership. And it looked like parents involved and engaged with their child. So Danielle, what are your initial thoughts?
Well, I'm thinking, I think it's important to like teach your kids that, even if that's not a hobby of theirs. If you're going to have a weapon in the house, you need to teach them how to use it and gun safety rules. I wish I would have already took my son to do that. That's one thing I need to do because we do have weapons in the house. So I think that as parents, that's a responsible move. But seeing that all this is happening, I guess it just doesn't look good, but
well, it doesn't look good
parents,
because of after the fact, but
after the fact, because of what took place,
right.
And if, my son were to go out and do the same thing, I'd feel responsible as a parent, I enabled it. But then again, I have to trust that I did what was right by him by teaching him how to do that. But this kid ended up finding this to be a hobby, right? That's something he enjoyed. And the parents were aware that he had mental illness, correct?
No, there's no diagnosed mental
There's
illness,
no diagnosis.
and
Okay.
they're not aware of anything. That's the other thing too. Yeah,
I thought I heard that they knew that he was okay. That was just stuff that
you're watching the wrong media source.
I'm watching the wrong stuff. I listen to my dad's news feed.
Yeah, no. And so the defense is actually asked, and the judges granted Ethan's medical records to come in to this trial because he hasn't been diagnosed with anything. They had a whole Miller hearing and psychological evaluations for his sentencing, for Ethan's sentencing. Mm-hmm. And he hasn't been diagnosed with anything, even now.
And the parents didn't think anything was wrong with him.
No, he was an odd, quirky kid that didn't have any friends and no hobbies.
And there's several kids like that. Yeah. And they end up getting homeschooled or something like that because of bullying.
Whatever. Yeah. But which I don't homeschool your kid because of bullying.
I hear a lot of that. And I know a lot of parents that homeschool their kids because of bullying.
Yeah. I don't think that's appropriate. I think there's some utility to bullying, not like the knock down, drag down, beat up kind of bullying, but the teasing, the all that stuff. It's character building, right? We talked about this yesterday too a little bit. Why kids are doing these things, shooting up schools and things like that. Not that it's an epidemic because it's still a rare event, but
sure.
If we talk about kids with guns in schools, that's not the issue because we had more kids with more guns in schools, 50 years ago, 40 years ago, or longer. So why? I mean, they used to teach shooting in school. So why? What's going on now?
Yeah.
And I believe it's the anti-bullying campaign.
Sure.
Everyone's so sensitive. People can't take a verbal jab without overreacting to it. Everyone's got to be in their safe space.
Oh, sure.
Oh, the
Yeah.
gun expert is here. Welcome, Jung.
Hey, Jung.
But I don't know. But that's my thought. Kids are weird. Yeah, kids are weird. I was weird.
We are.
Jamie says I was weird.
Imagine
Everyone's
that.
got to
They would
stop
be
freaking
weird as a
texting me.
kid.
If Julie, I know you want your shout out. Okay, so stop texting me, Julie. Stop texting me. I'm gonna block you. It's my sister-in-law.
She wants her shout out.
She wants her shout out.
That's
But
cute.
good morning, everybody. We're just waiting for the court feed to start. We have the Zoom feed. The jury was supposed to arrive at 8:30. It is now 8:44. So I'm assuming they're getting everyone together, and we will have a feed up at about 9 o'clock, probably.
Now, you've been to this courthouse, right? Was that the same courthouse that you were at not long ago?
Yeah, I was there just on Tuesday for
Okay.
jury selection.
Oh,
And yeah, so I was there. And if you guys followed my case on Megan Amirowitz, she was the Oakland County teen that was charged with unaliving her father by throwing lye on him while he was sleeping. And she was eventually convicted. I think that was wrong. I covered that case. I was also kind of poking around in the courtroom for that case as well. But she has become friends with Jennifer Crumbley while they were locked up in Oakland County Jail, and they still communicated going forward. I saw her in court on Tuesday, and I said hi to her and everything. She had been on my channel and been interviewed as well as her mother. But apparently now she's a state's witness. And I'm not sure why, other than maybe she was maybe Jennifer said something to her or something like that. She's a prison snitch witness kind of thing. So I'm curious to see what happens to that. And I was going to have her on the stream to stream with us, but I can't anymore. So she's a witness. And I didn't know that until they addressed it yesterday morning, that Megan Amirowitz was in the courtroom for the start of the trial, even though she was a witness and she had to be excused. So are you saying they taught shooting in the 1960s? They used to teach it shooting in the 1960s, 70s. I think they stopped doing it in the 80s. I'm sure there are still some schools that teach, shooting and things like that with 22s and whatever. But just because there are guns with kids in schools doesn't mean that there's anything that's going to go wrong. The attorneys are allowed to argue in front of the jurors. I do. That was one of the things I'm not happy about. The other thing is the judge questions witnesses, which the judge is completely allowed to do, but she questions it in a way where she doesn't understand what the attorney was asking. And then she makes a comment that makes it worse, rather than allowing the attorneys to just follow up with their questions. She's trying to be too helpful, I guess. But I don't like they're allowed to argue in front of the jury. This part, I'll play a clip here real quick. This part, though, did not take place in front of the jury. I want to say that. But this was bad, too. I think both sides were bad in the way they handled this particular situation. They're watching a video from inside the school, and now this is the end of it. This is from yesterday morning. Nick.
Say it again.
Morning, Nick.
So sorry. Can we just have a minute, like a break or can we have a 10-minute break, please?
You may be seated.
Runner, this court, upon the defense's request, instructed the prosecutors not to show emotion. You instructed the prosecutors to tell our witnesses not to show emotion. And you instructed us to let our victims know. I understand the ruling, Your Honor, I do. You're concerned about influence of the jury. I take no issue with it, but it was a difficult thing. It's difficult, and we're doing it. And then to have not just the defendant, her lawyer sit there sobbing. So
I did not sob.
I just want to finish, Your Honor. I just want to finish.
I did not sob.
I think if
It's
if
funny,
that
at
was
one
the
point,
instruction,
you hear it.
We are
I don't
trying
wanna-
really hard
yeah.
to respect the court's instruction because I understand the reason for it.
Okay, I didn't tell people not to show emotion. Some of that is involuntary. But there have been times in this courtroom during trials when people will show facial expressions or things like that, or make comments. I understand, this is a very emotional situation for everyone here, right? If someone was audibly sobbing in the audience, I would hope that they would exit. And as you said, the reason for it. I didn't tell anybody not to show emotion. I guess some emotion is involuntary. So I guess I'm asking what you're asking of me.
I think it should apply to both sides. It
Your Honor,
should.
first of all, I was not sobbing, and this is horrific. This is horrific.
I've never seen this before.
It's horrific. That's why we asked the court not to play it. This is horrific. I don't know how the
But
prosecutors.
it's
She's watched it 100 times with these witnesses. It's horrific.
You've had this video for over 2 years.
I don't know. I don't have this video. I have to go to their office to watch it.
You've seen it.
No, I haven't, because it's not necessary. It's not relevant to my client's case. We've already litigated this, but we're doing our best. We were not sobbing or making a scene in any way. All my eye makeup's still on. I checked my camera.
All my eye makeup is still on. That's the line. She's like, I wasn't sobbing. All my eye makeup is still on.
Yeah,
People
there's
are
no
asking me-
smudges here.
People are asking me to get an interview when this trial is done so they can ask her what kind of mascara she's looking or she's wearing.
Yeah, let me know.
I think both attorneys were acting inappropriate in
Yeah.
this response. The defendant's counsel is acting very defensive, and Karen is acting very snarky. So just to give fair commentary, I don't think either attorney handled this in a professional manner.
I need to run to
just
the
wanna make a
bathroom.
record.
I need a break.
Okay, we're having a break. That's what we're doing. And you have to keep your voices down because
I'm sorry.
the walls are cardboard.
So dramatic.
I'm sorry.
I know.
All right, everyone here is human, right? Everyone here is human. I understand that. I'm striving really hard to
This was
keep
so
both sides
dumb.
of their trial, and if people don't at least try to check themselves, to exit if it's that excruciating, which I know it is. I'm not a robot. I'm trying to keep myself from sobbing. I'll do it at 6 o'clock tonight. Okay.
I appreciate that, Your Honor. That's all I'm asking.
Okay.
That's all I'm
Your
asking.
Honor, we don't have the option to leave the courtroom. We're trying our best.
Okay, stop.
I promise you, we are trying our best.
All right.
Thank you.
Go. Yeah, see, so I think she acted very irresponsible. I wanted to say too, Jennifer Crumbley is aged dramatically in the last 2 years.
Hmm.
From when you first saw her in this mugshot 2 years ago. to
She's
now.
gained a lot of weight too, huh?
She's gained a lot of weight, and she's gray and not at all the same person.
Yeah, because they look fairly young.
Yeah, right.
Okay.
This is them 2 years ago. And
So they have to be in their like 40s, maybe.
She's 47.
Okay.
She's 47, but she looks much older, don't you think? Okay, hang on. Hang on.
Psychiatrists who
This
evaluated
is live.
the
Can you guys hear it okay?
and
Mhm.
and it appears that we have an issue that the shooter will not waive privilege.
Okay, let me ask you something. When we left yesterday, I asked whether there was any issues. I really do not like to use the jurors' time talking about these things I'm aware of this issue. I'm frankly irritated because I feel like the court has been very timely in responding to the attorneys, and I don't. The scheduling order had a motion cutoff day in December, and I don't appreciate the during the trial homework assignments for the court. That being said, I'm aware of this issue, but that's why I asked about it last night. I do plan to make a ruling on that. We've done some of our own research. I've gotten motions from those two psychologists, but I'm not going back a year and a half and changing my ruling that could have been appealed at that time.
Well,
I know that things have happened since then, but those things were subject to appeal. The motion to quash the denial was appealed. All kinds of things were appealed. This case went to the Supreme Court for a year. I'm pretty sure it was coming back, which it did. And I know that
Yes, this is live.
could file anything then, but these rulings were made a year and a half ago, and there's reliance on those, and no, the Court of Appeals and the Supreme Court have not told me that that was error, that I shouldn't do that, or anything like that. And I think there was opportunity to appeal.
Your Honor, there was opportunity.
Mhm.
We did appeal. We appealed to the Michigan Supreme Court. The court is absolutely right.
Mhm.
The problem is, even after the motion cutoff, my office received records from jail psychiatrists that I need, that has important information.
Okay, let me tell you this. We're not arguing that motion right now.
I understand, so I'm just
Yeah.
placing my objection on the record, because part of what I've asked for is that the evidence I am not going to be able to contradict that's going to come in through this witness is leaving me absolutely hamstrung. If the court rules that these psychiatrists cannot testify and the shooter is not going to testify, I'm left with this evidence coming in when I now know things I didn't know at the time. And I just learned these things,
So-
and we just got the objections to these people testifying, and from Sato this week about Ethan
Ethan has
testifying.
said
That
he's
is
going to
not
plead
true.
the fifth and not
That is
testify.
not true.
The
So they're
state
wanting him to
wants-
testify.
Jury's attorney,
or
Ms. Lofton, asserted that privilege at the time that I provided the records. The records were provided
or
under
prevent the
protective
state
order. The
from
records,
introducing
are
the shooter's
subject
text
to
messages
an absolute
and
privilege
journal
that we
because
have
they
been
can't cross-examine
researching
him
for
if
the
he's not on
past
the stand,
week.
but the state still wants to
There-
introduce the
there's
writing.
absolute privilege, as far as I can tell. If you can find me
I
a
can't
case that
pause it right
says
now.
there isn't one, I would be happy to read that. We have spent a lot of time on the homework assignment we were given while the trial is in full swing. I have found nothing that says those records aren't privileged. The privilege was asserted by Ms. Lofton at the time that you requested the records. I know it was asserted again by Sato, their new attorney, but it was asserted back in November. I could
Because
give
he's
you that date
appealing
if
his
you want. At
sentence
the time that I
to
provided,
no
I
parole.
provided those records under protective order because they could the prosecution had the records, and because they could potentially lead to exculpatory evidence on behalf of your client.
Does it
I
sound
didn't
okay
plan
when
on
you talk,
ruling
Danielle?
about this
Mhm.
today, but I guess I would direct you to the Stanaway case that talks about review of records, but that's of a
That's the
victim
problem,
witness's
Dory,
records.
is that it's
And
hearsay.
and in that instance, there was an in-camera review, but there has to be a threshold showing that there would be relevance. I don't have that either. So I'm working as hard as you guys are right now. So at the moment, I'm not going to go back and change my ruling from a year and a half ago. I think everybody has had ample time. When something is filed, I respond to it in a very timely way, despite the fact that I have one or two other cases. And I'm not changing my ruling from a year and a half ago. You could have appealed it to the Court of Appeals, the Michigan Supreme Court, the US Supreme Court, whoever. So
Your Honor, I'm not asking the court to change its ruling from a year and a half ago. I'm asking the court to make a new ruling based on new information that I literally got this week. I literally got this week that Ethan Crumbley will not testify pleading the fifth, and that
I'm sorry, I have to interject. We brought this to the court's attention November of 2022. We've discussed this
Are you talking about the 803 statements?
All of it. All
Okay.
of it. And I don't mean to interrupt the court, but just to supplement what the court indicated, counsel for the shooter filed an objection in November of 22, and then filed another objection regarding privilege in October of 23. And at one of the very first hearings in this case, we talked about how it would be near impossible for this attorney to call somebody with a Fifth Amendment privilege. We have Fifth Amendment privilege. We have the privilege in the mental health code. And there's also the issues of hearsay, Judge, and there's nothing inconsistent in any of this. And counsel's had all this information.
Well, and Your Honor, I subpoenaed those three doctors. Those three doctors coordinated with my office to find time to come in and testify.
Okay, and how can they testify?
And then they had attorneys file motions this week while we've been in trial. And I filed a motion while we were in trial asking for alternative relief. I'm not asking the court to change its prior ruling.
Okay,
I'm asking the court.
I have found no legal basis for your alternative relief, and I have tried mightily.
Well, the alternative
privilege is
relief,
absolute,
I agree with you. I'm not talking about the privilege, but I'm saying when the privilege is absolute, if the privilege holder will not waive it, the court rule says, and it doesn't have to be a complainant, it doesn't have to be a victim. It says if the privilege holder will not waive it, their testimony cannot come in. And what this court is going to allow to come in through
the privilege holder is not testifying.
I understand that, but the problem is the evidence coming in are statements this privilege holder made, and I have no way to cross-examine to show the inconsistencies and the important information.
I've received no offer of proof about that. I don't know if there's inconsistencies or information.
There's not. This argument isn't based on a false premise. And this
Okay.
is something we've been
I don't
saying
know
for
that.
months.
I don't know that. There's been no supplemental filing saying that there should be an in-camera review for some reason. This person is not testifying. The shooter is not testifying. So how is he someone who's providing testimony? He's not. Those are statements that were provided under 803. I was not prepared to have this discussion today because this morning, that's why I said last night, anything. The jury is waiting. I would say that
So I was wondering if we were going to address this yesterday.
We had last week. I think it's disingenuous for the defense to say that they're surprised that the shooter would be taking the Fifth. You are a very smart, very experienced attorney, and all this stuff is sitting on my desk. There's a case, Jackaloni, right? You can't put someone on the stand knowing that they're going to take the Fifth. And aside from shooter, what's your favorite color? What question could you ask him that would not implicate his Fifth Amendment rights?
Okay, I'm sorry. This has
Sorry,
to
that was going to that played double dip.
Well, it's not going to be a clear record now because the jury is sitting there.
I asked to have the shooter brought in after the issue of privilege was brought up by the shooter's attorneys and by the attorneys for the doctors. I was not planning to call the shooter until this privilege issue came up this week.
No, the privilege issue came up in November.
On the actual records,
yes.
Not on the testimony. The testimony is all impeachment.
What testimony?
The testimony
all
that
your
I
questions. I'll
anticipate
come back to
these doctors will give is straight impeachment of things the shooter said.
I need to correct the record. It is not. And Dr. Anneker informed me that she had a conversation with defense counsel last week when counsel tried to subpoena her, and Dr. Anneker explained that to counsel that it is not inconsistent. She
That's
actually said
not
that.
true.
I don't know. I don't know
true.
if it's inconsistent or not. I have not read the records. I have not read these records, but the privilege was asserted at a minimum last November by the shooter's lawyer, and try as I might, I cannot find an exception to that privilege. That privilege is absolute except in limited
jury's
purposes.
not there.
The privilege belongs to the shooter, and it's been asserted several times. I have personally, and my staff attorney, been looking for something that would support your position. The closest I've gotten is Stanaway, and that is a victim witness, and there was a threshold offer of proof by the defense regarding what should be searched for in an in-camera review. I am obviously not in a position to do an in-camera review of those records right now, nor have I been provided with some glaring thing that the shooter said. I lied when I wrote X in my journal, whatever it is. So
Your Honor, I am going to put together an offer of proof of exactly what these doctors would testify to. I understand the court has not ruled yet about these doctors, aside from the fact that the
I'm pretty
privilege is
close.
absolute. I understand that. I cannot file that because
I
of the
understand.
protective
No,
order.
you can't file it.
So I'm gonna put it together. I'm gonna
Okay.
get it to everyone, and obviously we'll go from there. But I also want to state the privilege, obviously we all know the Fifth Amendment. This shooter has pled guilty. He's been sentenced. It's our position that at this point, he does not have the same Fifth Amendment rights as, for example, James
Support
Crumbley,
it.
It's just not the
whose
law.
trial is not.
Okay, support it, because every lawyer in this room knows that that sentence is going to be appealed until well after I retire.
Well, and the other thing is the evidence I intend to put in front of this jury, quite frankly, is evidence that the entire world knows about because it came out at the Miller hearing.
That's
Okay,
not
so-
the test
okay,
for the law.
You're
or the
telling
evidence.
me why it's relevant and why it would be fair to you to admit it. I understand why you want it. I understand why you want it. I haven't seen it. I understand why you want it, but I have to follow the rules. Believe me, I've been researching this issue. and
Well,
if-
and I'm sorry, that's why I'm pointing to the rule about when the privilege holder won't waive it and when the privilege holder won't testify and can't testify. I'm going to the third option, which is that evidence just can't be used. If I
Okay,
have
I'm
no
sorry,
way.
this is non-testimonial evidence that's being admitted today, not testimony,
It's-
non-testimonial evidence,
It's
I'm
not
not finished.
testimony.
Not testimonial evidence, and that's the basis of this court's ruling. There's no Crawford issue, there's no confrontation issue, it's non-testimonial. If it were, we'd have an issue. We don't.
And I believe the Crawford issue is preserved, and this is testimonial because this is information
They're
that is
trying to
tantamount
introduce
to
text
testimony
messages
in
and
this
journals
case.
from Ethan today.
not the
It
law.
sounds
The,
like.
the rules of evidence, 8033 specifically, 8031, talk about present sense impression. I did a thorough evaluation of some of those statements at that time, which was about a year and a half ago. What month was it? Maybe I'm blocking it out. I evaluated all of those statements and I made a ruling based on a hearsay exception where the declarant whether the declarant is available or not is immaterial. So whether he testifies or not is immaterial, which says to me it's separate. Those statements are separate from any testimony. The person who made those present sense impression statements, whether they testify or not.
Be right back.
That's what 803 says.
I hate the present
the theory
sense
behind
exception.
it is that it's done in a contemporaneous way. So I made those rulings a year and a half ago, and I invited anyone to appeal anything that you wanted to appeal. There was a motion to quash. There was a lot of things appealed, and that could have been appealed as well. So it's not that people haven't, that either side hasn't had the opportunity.
I know you
So
guys like
I
the
will
sound
read
quality
any
of
case you
this, but
provide. I have
I
been
can't pause it, so I'm going
researching
to switch over.
whether or
eventually.
not those records could be admitted, and I have found nothing that would direct me to allow doctors to testify about privileged
That's a good
records
question, Aaron.
that have not been waived by the person who holds the privilege, and that person is the shooter. And that privilege has been asserted repeatedly by Ms. Lofton and by Sato. I will read any case you give me, and I've been frankly trying to help you. I can't find a case that allows for that. So
Your Honor, the only cases I can find, and I think it's because this is a unique issue, and there has probably never been a case like this with parents who are also charged with murder type crimes, and the shooter is charged with a murder crime
Yeah, it is a
that he
thin
pled to. So this is a
legal
very
sta-
unique situation.
I'm aware.
Unfortunately, it's a case of first impression. I know the court knows this. And so when I look at the cases, I agree with the court that most of the cases deal with a complaining witness or an alleged victim and their rights. But the court rule says privilege holder. It does not limit it to complainant. And I agree with this court. There's not case law. And that's why I'm asking this court to make a decision to not allow these statements pursuant to the court rule, because I have no way to defend them. But if the court's ruled, the court's ruled.
Okay, well, I didn't plan on ruling on that this morning. I mean,
I will still
If
file
you-
an offer of proof, and I will still file a list of what the evidence would have shown. And I understand the court will make a decision about the doctors testifying. That's the best I can do.
okay, well, I'm doing the best I can do.
I
so-
know you are, and
Anything else? Anything else?
Just really quickly, what the court rule says is that if the privilege is absolute and the privilege holder refuses to waive the privilege to permit disclosure, the trial court shall suppress or strike the privilege holder's testimony. I'm not done. Testimony, and this is non-testimonial evidence, what we just said. There's nothing more. This isn't a case of first impression. This is the law. It's been the law for a very long time.
well, the problem is,
okay,
I
that's-
want the testimony, and I'm being told I
Okay,
can't get the testimony.
That is directed at a person who puts, like someone who is in a car accident and they're suing an insurance company and they're putting at issue, they say that I've been depressed, I can't leave my house since this accident, whatever it is. If they testify to that and then they object to having their mental health records admitted, it's problematic because that person, the witness, put their mental health issue in that case at issue. They put their mental health at issue. And so you can't use your shield as a sword. That's what that is about.
Correct.
So if you are a witness who's alleging damage to your mental health, yet you will not waive the privilege with regard to your psychological records from mental health treaters, then that testimony is stricken. There's a reason for that. You can't use your shield as a sword. That is the reason for that. That is wholly separate from this issue. With regard to asking the shooter to testify, it's not that I'm saying you can't call him as a witness, but two of his attorneys have said in no uncertain terms that he's taking the fifth. Both sides, not just the prosecutor. Again, I think that's Giacalone. I don't know. All of this stuff is sitting in my desk. You are not allowed to put someone on the stand knowing that they're going to take the fifth. And I cannot think of a single question beyond what is your name that would not implicate his Fifth Amendment rights. So I don't know what you could even ask him that he would answer or that his lawyers would let him answer. So it's not, I am going to prohibit you from putting any witness on the stand who takes the fifth in front of the jury. That is strictly prohibited. So are there other questions that you could ask him? I can't even imagine that would not implicate his Fifth Amendment rights. That's the problem. I understand your problem. I understand the difficulties. I do.
The
And
$5
if
super
you knew
chat
how
from
much
Kingslayer. Well,
I have
the judge
spent,
did
my
say
staff
she
attorney
was
have spent
trying to
on
help
this.
the defense by
It's
finding
mind-boggling.
authority
But at the
to
moment, I
grant the
have
request,
nothing
but there is
that
no case
lets
law.
me say, I have to rule in a way that is the most fair for the defendant, but goes against the law as I know it. I don't have something that lets me do that. If someone has something that lets me do that, I would be happy to hear about it. Okay, I'm bringing the jury in. Okay.
Thank you, Judge.
I was about to ask if they were doing this in front of the jury.
No. I'm going to switch over, guys. I know you're going to all complain about the audio, but the problem with this feed is that they cut out when there's an exhibit that they don't want you to see. We don't have audio at all. We don't even have like the witness on the stand. So I'm just going to end this entirely and then just do the other stream for now. We're not missing anything at the moment. So just turn up your volumes, folks.
I know it. I don't have something that lets me.
See, I can hear it just fine. Danielle, can you?
Yes,
Okay.
perfect.
Okay, so I start a bunch of questions. How is case law made? Case law is made by an appellate court, not a trial court. So the defense, I start a bunch of your questions, but the defense was asking that the court make a ruling contrary to
All right for the jury?
the support law, and she is unwilling to do so because she doesn't have any authority. So now, if this ruling, as it stands, goes up to the Court of Appeals, the Court of Appeals says, no, this trial judge made the wrong call. You need to go back to, and do it over, and in fact, not allow the journals to come in. That would be then case law in this particular circumstance. I have a bunch of questions started.
Edward Grafsky.
All right. Let me just pause real quick and try to get to these questions. All right. So why do they do jury instructions at the beginning? So they do preliminary jury instructions at the beginning, and then they do closing jury instructions at the end. They do them on both. And if special instructions need to be had at the end, they will provide those. Did Julie F. angrily leave you? Make us leave? What? I don't know. She's here probably. Napoleon, are you going to cover the sidebar in front of the jury? We talked about that yesterday. They had some sidebars, which I don't think was appropriate. The judge needs to address that. Hopefully she's going forward. Why are there so many officers? Not because it's a high profile case. There's not a ton of people in the courtroom, but I think a lot of the officers are there for the defendant, but also in case, it's an emotional case and there might be people in there that are just angry. And so they want to make sure everyone's safe. Are they arguing about Ethan's journals and texts I just joined? Yes, they are. That's what they were arguing about. The state has intended to introduce them. The state has the permission from the court to introduce them under sort of present sense impression and business record rule sort of thing. It's like, well, if we wrote them down while I was thinking it, the foundation is that the journal was found in the backpack. They have other witnesses that can establish the foundation. The text messages and all that stuff was data dumped from his phone. They have other officers that can admit them. And the defense's concern is that they can't cross-examine those journal entries or those messages. The only thing that they can cross-examine is the person who wrote them. And if the person who wrote them is not going to testify because he's pled the fifth, then the defendant is in a position where they're being confronted essentially by a witness, the journal statements and the text messages, the witness being their son, and they can't cross-examine him. And you have a right to confront the witnesses against you. So it's this weird little balancing act. And the judge says, and I tend to believe the judge, there's no case law establishing what to do other than the normal, which is when you have these situations, if you have foundation to admit it, then you can cross-examine the witness who admitted it. So it's and the defense attorney is right in that this is a weird, novel situation. You don't have this all the time, where you're essentially being charged with the intentional wrongful acts of a third party. How do you deal with this evidentiary issue? The Court of Appeals will have to address that going forward. But right now, as it stands, it sounds like there is no case law that helps them. How is Jennifer paying for her attorneys? I believe they are pro bono, but they are privately retained. They're not court appointed. Making law simple. Has she actually presented any authority, or is she just talking? I think she presented the court rule, which outlines exactly what you're supposed to do. But the judge is reading the court rule one way. She's reading the court rule another way, and she doesn't have any authority to say, Judge, you're wrong. So it is what it is. All right. Hopefully that got through all the questions, and we can get going here. Danielle, any thoughts, questions?
No.
Okay. Nice follow-up.
Raise your right hand. Do you swear or affirm the testimony about to give is a true self of God?
Yes, ma'am.
Right. Could you
Oh,
take a
this
seat?
guy.
Could you have a seat?
He's the one that introduced all the text messages and journals in the
And then
preliminary
could you
exam.
state the record disclosure for students?
Edward Wagrowski, EDWARD, last name WAGROWSKI.
Right.
Thank you. Good morning.
Good morning.
Sir, how are you employed?
I am employed with the U.S. Secret Service,
How long have you been with the Secret Service?
just a couple weeks.
Now, prior to this
He was
current
Oakland
job,
County.
where you were,
The Oakland County Sheriff's Office,
Oh, okay.
How long were you with the Sheriff's Office?
28 years.
Okay, in those 28 years, where did you work?
I started out in dispatch and went to corrections after that, the road patrol, and then eventually to computer crimes.
Okay. And tell me, when you say computer crimes, what does that mean?
Do anything that has to do with a computer, cell phones, forensics.
Another
examination
Fed
of computers,
on the stand.
DVR equipment called detail records.
How long were you in computer crimes?
10 years.
In your time in computer crimes, did you receive specialized training with forensic analysis of electronic devices?
Yes, sir.
May I approach the witness?
Sure.
This is exhibit 422. Sir, just confirm for us that that's your CV.
Teen with BS and text and journals. Yeah, that's what this guy's going to introduce.
Oh, no, I'm sorry. No objection is admission, and
Yes.
also no
Right.
objection to disqualifications.
CV, so you would.
No.
you would stipulate his qualifications, you would stipulate he's an expert in forensic examination computer.
I'll have to
Yes.
pull up the statute to verify
Cellular
this.
cell phone forensics, historical cell site analysis.
I'm going to
That's
start,
the
come back
defense
to it
that gives
daily.
To both of those, the CV and that he's qualified as an expert.
Historic CV.
Cell site analysis, and cell phone forensics.
Historic cell site and cell phone. Okay. You may consider him as an expert in the area of historic cell site analysis and cell phone analysis.
Yes, sir. Thank you. Well, sir, now we don't have to go through the entire CV, but let's just talk a
Yes,
little bit
please,
about
thank you.
training as it pertains to cell phone.
I hate when they
downloads
go
and
through
forensic
that whole
analysis.
thing.
Yeah.
So is it fair to say that this field is evolving?
Always.
So you said you spent 10 years there?
Yes, sir.
What sort of things did you do in computer crimes 10 years ago?
Things were a lot different. It was actually a lot easier to do forensics back then because with updates of how the phones operate, how Apple or whoever Android operating system, they just make it more difficult. And now we have to figure that out.
What do you mean more difficult?
With encryption, file-based encryption on a hard drive, so data that you hold personal can't just be taken off the phone and given out to whoever.
So talk to me about what a detective in computer crimes, or first of all, what your current role at the Secret Service, what exactly do you do there?
I'm a network intrusion forensic analyst.
Okay.
Just looking at
what are
your
the
stuff,
same sort
people.
of duties you had in computer crimes?
Yeah, the same thing that I did, cell phone analysis, computers, just with more network intrusion, like someone hacks into a bank or something like that.
Okay. So walk me through, what is a typical day for a expert in the area of cell phone forensics?
Typical day is you come into work, you just see what work needs to be done. Really the case, depending on the case, how important it might be to get that, to either examine those phones or contact the detective that brought that stuff in to see exactly what they're looking for on those devices.
So you'd be somebody to receive the cell phone, seize an investigation, and then conduct an investigation into that device.
Correct.
Okay, so what does that entail?
That entails, depending on the device, we have tools that are able to obtain the data from the phones. And then we then take that data because it could be voluminous, thousands and thousands, hundreds of thousands of pages.
I'm not
Put it
sure
in-
about.
Celebrate is the company, and they make a forensic analyzer reader, which makes it easy to look at.
So that reader, that's one of the tools, forensic tools you mentioned?
That's not the tool that we use. That's what we give out to investigators. The tool that we use is a little bit more than that reader tool, what the functionality that it gives us. But the reader tool makes it easier for the average investigator to look at.
Okay, so let's help me understand this. So a phone is taken as part of the evidence, a search warrant's obtained for that phone, and then you're given the phone itself. Is that right?
Correct.
Okay, so tell the jury, please, what do you do with the phone? Walk us through that step by step.
Depending on the phone, again, if it's passcode protected, if it's not passcode protected, there's different steps that we have to do. We hook it up to the tool. In this case, it would have been Celebrate, again, as a company, and the tool is their Celebrate Premium platform, and that's able to obtain what's called a full file system, which is everything on the phone, everything you can get off of it, as long as there's not encryption on it.
What is encryption?
Encryption is, how do I describe it? I don't make it easy. It just jumbles up the information. It makes the word "the" look like absolutely nothing that you could understand.
Okay. So as an investigator in the area of digital information, you don't confine yourself just to a cell phone. Would that be right?
Oh, that's correct.
Okay. So what other sources of information would you draw upon as an investigator?
Someone's social media accounts, Facebook Messenger, Snapchat, all that stuff, anything you would download to your phone. And obviously the phones are cell phones, so you'd want to get the cell phone records from the carrier.
Okay. Now, talk to us about how you obtain that information from other sources other than just the device itself.
Via search warrant.
Okay. And before a search warrant is sent, do you send something else?
Yeah, there's something called a preservation letter. What that does is it In order for us to get a search warrant, you have to have probable cause or reason a judge to believe that the information you're looking for is going to be there. So while we're trying to gather that probable cause, we tell AT&T, don't destroy these records under any circumstances for 90 days until you hear back from us.
Okay. Now,
He's not credible unless he throws the
as
phone
an
around, right,
investigator,
Danielle?
why is it
That's the
important
standard.
to not confine yourself to just
Yeah.
the device itself? When I say device, I'm talking about cell phone. So why would you not confine yourself just to that cell phone?
Because sometimes the stuff isn't always stored on the phone. It could be stored on a server, and the computer system, like again, Facebook, for example, or Instagram, that information isn't always stored directly on your device. It's stored on a server that your phone just accesses.
Okay. So is it your goal then as an investigator in computer forensics to gather as much information as possible?
Always.
And then when you gather that information, what do you do with it?
Start talking to the OIC, it is called, the officer in charge of the case. What are you guys looking for? What do you need? How can we help you? Basically.
Now, is every cell phone the same in how they store and transmit data?
No, sir.
Okay, tell me the differences.
The difference is, like, to put it plainly, the more advanced the phone, Apple, for example, or a higher end Android device like a Samsung, could have file-based encryption, where a lower end phone doesn't necessarily have that file-based encryption.
Do you know why that is?
It's just whatever the manufacturer wants to put on the phone to keep the cost down, to not have as many developers and all that stuff. You just keep the cost down by not having that as part of your platform.
So if the user of a phone is spending more money for the device from a certain manufacturer, they can expect to have a higher level of encryption. Would that be right?
Yeah,
No.
and features, yes.
I don't think
Yes.
so. That seems
So
like a
then,
stupid
is
question.
it possible to recover deleted content from a phone?
Potentially.
And why is it potential?
Potentially because, again, you go back to that file-based encryption that I've said over and over. Is if it's, once you delete something on your phone, it's not necessarily always deleted on the phone. It's just encrypted. You telling it to delete it just erases the path to get you that encrypted data. And so we can't find it.
So it has nothing to do with the forensic tools at your disposal. It's regarding the manufacturer of the device itself.
That's correct.
Okay. Now, you talked about how some information can be stored on a server as opposed to a device. If something
This
is
is all
deleted from a
foundational stuff.
phone,
You're just going to
by
get the
user,
text
are you still
messages.
able to recover it from the server?
Potentially, yes.
Okay, and tell me in what circumstances.
For this
guy doesn't
situation, in
understand
particular, I
encryption.
did some research.
Is he not just
Facebook
dumbing
Messenger,
it
for
down?
example,
I don't care about this guy's foundation. Is he not just dumbing it down for us, Hammer, or does he really not understand? That's my
where
question.
Facebook-
Because sometimes I try to
the other person
dumb
wants to
stuff
see the
down,
conversation,
and I feel like
they'll
if I'm
delete it to that
talking to
person,
another
so we
attorney,
have
they're going to
conversation
think I'm
that
an
they're
idiot.
Okay, so
Is
let's
he
say
doing
you and I
that,
have a
or
Facebook
is he
Messenger
really
chat,
not know what he's talking about?
and I delete that from my phone. If the investigator wanted to recover that information, it wouldn't be on my phone. Is that correct?
Possibly, yes, correct.
Okay, but then you could send a search warrant to Facebook, to the server, and obtain that information.
Correct.
Okay. Now, what if you and I both deleted it from our phones? What would happen then?
According to what I looked up and looked into Facebook's website, that it won't be available.
Okay, so then it's deleted completely if both users of the chat delete it.
Correct.
Okay.
Over under on the amount of donuts. All right, let's do a poll.
Now, what about deleted text messages on the device itself? Tell me how that works.
Yeah, it just comes back to possibly being able to delete or retrieve deleted text messages on how they're stored in the phone, if the database is still available, or if the app's totally deleted from the phone, and all that data is stored in the phone, and I tell it to delete that app, then it could possibly be totally gone.
So if you were to review, let's say, screenshots from one person's phone and then a forensic analysis of somebody else's phone, if the screenshots didn't match up with the forensic analysis, what would that tell you?
That was possibly deleted.
Okay. Now, during the course of this investigation, People versus Jennifer Crumbley.
No, I kind of
did you
want to
uncover
donut. now.
evidence of deleted content from Jennifer Crumbley's phone.
That's correct, yes.
Okay, and we're going to get into that later. But before we do, could you tell us just in general terms, what does a cell phone do that maybe a layperson wouldn't know?
It's continually working in the background, talking to a cell tower. One, so your carrier knows where you're at, so it can give you the phone call if someone's trying to get a hold of you, or the text message. Or it is updating your email account without you telling it to do it, because the application is just constantly looking for that signal. So you open it and there's the most updated information.
So that's when the phone's
Morning,
powered on, right?
Stray.
Correct.
Okay, so when the phone's powered on, it's constantly doing
Morning,
it,
Stray.
right?
Yes, sir.
Okay.
This
And what
guy's
about
going
the
to
phone's powered off?
testify about throwing a
It's doing
phone.
nothing.
Guarantee
It's
it.
just off.
Okay, so it can't update.
Correct.
Okay, so when a phone's powered on, is it possible to obtain the location of that device?
Yes.
How so?
Because there's a feature, whether you have an Apple product or an Android product, each one of them has what they call location services, and it's actually to benefit the user of the phone. So because that information is sold to McDonald's or whatever, and next, you're near McDonald's and your device says, "Hey, I'm near McDonald's." Oh, cool! I'll send you an ad for McDonald's or a coupon for McDonald's. So that's
Okay.
Yeah.
So you have, as an investigator, a fair amount of reliability in that because of.
Wait, what's wrong with eating a donut and then drinking black coffee? I feel like those offset each other, right?
Right. Go together.
Hey.
Capability for
I sped it up to
somebody's
somebody.
phone to sell the device basically to an advertiser.
correct. Yes.
Okay. And are you able to obtain someone's location from their phone based upon other
Sounds
data
like
as well?
he's not
That's
going
correct,
to,
yes.
Christine.
And how so?
Through the carrier themselves, AT&T or T-Mobile, whatever you may have. Again, you're constantly, your cell phone's constantly talking to a cell tower, and they try to triangulate your position on where you are based on the signal back and forth from each tower.
Now, on an Android phone, for example, it automatically comes with a Gmail account. Is that right?
No, you have to make a Gmail account.
Okay, you make a Gmail.
Yes.
Okay. So if someone were to have a Gmail account, would that also help an investigator determine the location of that device?
Absolutely, yes.
Why is that?
Because again, those
We already
that information and
testified
location
regarding the
services are stored
location
within
of the
that
devices
particular Gmail
yesterday.
account that someone might have. So if we would search warrant Google for your particular email, the Gmail, they would have, if that's turned on, the location services would be given to us.
Okay. So I want to talk about the evidence in this particular case.
I want to go get a donut now.
There were a total of 7 phones recovered, and I'll go step by step with you. So I'm going to review with you. I'll show you a slide here. Some of the sources of available information. So you see that as a school shooter, his initials.
Yes, sir.
Now, is it true that you reviewed a T-Mobile phone, last 4 digits of the phone number 1551,
That's
a
right.
Facebook account,
Correct.
and an Instagram account?
Correct.
And you were able to determine, and we heard testimony yesterday, that both James and Jennifer Crumbley followed that particular account.
That's correct. They did.
Okay. So you were able to review not only the shooter's phone, but also social media, Facebook and Instagram for that individual.
Correct.
Okay. Now regarding Jennifer Crumbley's electronic information, you reviewed information from 3 phones.
Correct.
Okay, so we have one listed as an original phone. Are you aware that her original phone was seized on November the 30th in the evening?
Yes, sir.
Okay. And then you're aware that she purchased what we refer to as a burner phone or a track phone that night?
Correct.
Okay. And then that's the number, the 947 phone number?
Correct. That's right.
Okay.
Yep.
And you're also aware that subsequent to turning over her original phone and prior to arrest, she obtained another phone?
Correct.
And that was with her same original phone number?
Correct.
Okay, so you reviewed that device as well.
Exactly. Yes, sir.
So just so we're clear, when I say you review the device, we're talking about forensically analyzing.
Thank you, good citizen, for the 199 super chat. Have a donut. Thank you. I wish I had donuts here. I don't have any donuts here. I have half of a chocolate orange that I think I'll be diving into later. But what I wanted to say about the phones, right? Everyone's been made a big, they've been talking a lot about these cell phones, and the first set of cell phones that they had were taken by the police. So they went and got another set of cell phones, and those were taken by the police again because they logged into everything. So those were taken. So then they got like the burner phones, right? They're not burner, they're prepaid phones. They got the prepaid phones with new numbers and everything. And I believe those were also taken by the police when they were arrested, eventually and charged with this crime. So they keep buying new phones. They keep getting taken by the police. So when everyone says they took 7 phones and they had these new phones, it's because they kept getting taken by the police. So I doubt that's going to come out on direct, but I want you guys to at least have that content because the prosecution and the witness know that.
The data on that cell phone.
Correct. Yeah, exactly.
Okay.
7 phones
You're
equal
also
guilty.
able
Well,
to
that's how the
obtain
news media
information
is.
from Facebook, from 2 different Facebook accounts.
Correct.
Okay. And information from a search warrant served on Google regarding her Gmail account.
Correct.
Okay. And that Gmail account and that Yahoo account, does that include location data?
The Gmail account? Yes, yes, it does.
Gmail account.
Yes.
Okay.
John Gary, give
Now
me
regarding
the
James
evidence
Crumbley,
to support
Again, 3
this
cell phones.
because I've never heard this.
Correct.
Okay. His Instagram account,
Correct.
his Yahoo account,
Correct.
his Gmail account,
Correct.
an email through Charter Communications,
Correct. Yes.
and then a search warrant was served on DoorDash to obtain his DoorDash driving.
Well, if this witness testifies that the parents were not home when the son was taking the pictures in videos, then this witness would be contradicting the state's witness from yesterday, this lovely, beautiful gentleman who testified that, in fact, they were home when those photographs and videos were taken. So I doubt very much he's going to say that they weren't, because then you have state's witnesses contradicting themselves. And in my opinion, that's not good for the whole reasonable doubt thing. Nicholas Staroff with the 100 Swedish krona super chat. Thank you very much. Question from yesterday. Oh, if they tried the shooter as an adult, haven't the state waived the right to prosecute the parents? That was a question from yesterday. Thank you, Nick, for reminding me. And that was just Dia asked that. Why was he charged as an adult and the parents responsible for the child? Yes, we saw this question come in late yesterday and we forgot about it. Thank you very much, Nick, for reminding me about it. He didn't have to do it via super chat. You could have just messaged me, but I appreciate the super chat anyways. So under this theory, the child being an adult or a child doesn't matter. It would be the same. And that's why this is so dangerous, is that it would be the same regardless. The reason why the child is being charged as an adult has to do with the nature of the crime and the possible not punishment, but not reformation. I can't think of the word. So when you try somebody as a child in the state of Michigan, your goal is not to punish, but to rehabilitate, to get them counseling, therapy, or whatever, keep them, get them education and things like that. And then assuming they're a child, they can be saved and pushed back out into the society. The goal is not to punish. But in this particular case, you can't really see that as a foreseeable outcome. You need to lock this person away. You need to punish him. So they tried him as an adult, given the heinous of the crime. But that doesn't alleviate the parent's responsibility under the state's theory. So under the state's theory, it's just that they had a legal obligation to protect society at large from their known dangerous son. It doesn't matter if after that they charge him as an adult or a minor. So hopefully that answers that question.
Agent 3.
Correct.
Okay. Now, your goal with obtaining all of this information as an investigator into digital evidence is to obtain the who, the what, the where, the why, and turn that information over to the officer in charge and ultimately the prosecutors in the court. Is that
Correct.
Right?
Everything we can get.
Okay. Okay. So I'm going to show you People's Exhibit 76. I don't believe we have an objection to any of the evidence coming through officer or investigator we're asking to do.
No, we have several objections. And I believe many of them would be based on the record already, but let me open up 76.
This is 76?
76.
We have no objection to 76.
Okay,
And I'm sorry, with
Jennifer
this, I'm gonna have to
Crumbley
go exhibit-
followed son's Instagram. Yes, she followed.
Okay.
At least if the testimony is consistent to the preliminary examination, she followed one of his 3 Instagrams.
We have
So what are we
3.
looking at?
That is
The son had 3 Instagrams, and
My son
Jennifer-
has one. I follow it too.
I follow my son's, but he might have more out there that I don't know about,
That's true. Yeah.
right? So,
Mhm.
and the reason I got Snapchat is because my son was on it, but he might have, again, alternate Snapchat accounts that I don't know about unless I go through his phone. And
what we
then
look
he
at,
might be logged out of it. Who knows? You
printout
know?
from
You gotta do
Yeah.
a lot of
or somewhere
sleuthing.
physical analyzer program of someone's
Mhm.
information that came from their phone. And it's Jennifer Crumbley's followed her son's Instagram account.
Okay, so just to give us an idea of what we're looking at here, this is a snippet.
Yeah,
from
see, the problem is,
PDF
John, is I
export
don't know
from
this
that
to be
forensic
the
tool
law.
you use.
Correct, yes.
Okay, so tell me how that digital information comes to you and how it ends up looking like this.
I could see again in a negligent sort of circumstance or a child neglect against the parents, but not to the level of criminal culpability. No, not unless they were like co-conspirators or contributing, actively towards whatever the child was doing was illegal. Let's say the kid's robbing the stores all the time, but he's going there because mom's sending him. That's different, right? So
The reports, the information that we have, you can put it in any number of formats. You can put it in a PDF like this is, in a Word document or Excel spreadsheet. And you just tell the software what you want it to show you. And
I'm going to slow this down. He's talking really fast.
Yeah.
We're a little behind, but that's okay.
So
We'll
moving
get
on
caught up.
to Exhibit 77, this is a portion of James and Jennifer's Facebook messages.
I'll be right
Judge,
back.
I did want to place
You
on
hold down the
record
fort,
that
Danielle.
We do
I got
have
you.
an additional exhibit 423 that'll be introduced through this officer too. That's the entire Facebook message thread between James and Jennifer Crumbley. Council placed an objection on the record yesterday regarding that, so we're introducing the entire 2,000-page thread.
And Your Honor, I until I look at that 2,000-page thread, I object to it. My objection, I need to look through it. I might not object to it.
Okay.
My objection yesterday was about the exhibits the prosecution was showing, those individual exhibits. They deleted parts of those.
Hold on. Nobody deleted anything. This is
Well, then
demonstrative
let's-
aid. The exhibits are the same, and
Okay,
we're giving the whole thing.
Okay.
okay, and.
You can, they're admitting an exhibit and showing the jury portions of it. They're permitted to do that, right?
Right, so, but I'm just saying, my question yesterday about the parts missing did not mean I'm asking for all thousands and thousands of texts to be introduced.
Okay,
So I'm gonna take a look at them and see if we do have an objection, and we may not.
okay.
The other,
You've had them for a while.
what's that?
You've had them for a while.
Yeah, I
Okay,
have it.
January of 22.
I guess the difficulty is that the prosecution does not want the jury to get the impression that they're in some way hiding something or not presenting something to them. So they're presenting the portions of that exhibit that they think
Dude, what did I
are
miss?
relevant for purposes of this witness's
They were
testimony.
arguing a little bit.
Not that you want the entire exhibit in. The prosecution
miss
is
much.
saying we don't object to that.
Right.
So it's up to you. You can let us know.
Right, and I believe the only problem is this court's made other rulings where things are discussed in those texts that are not a part of this.
Okay.
So when I reviewed their exhibits as a whole. They're allowed to show different pieces of the exhibits, but that didn't mean I was suggesting we just admit the whole thing because you've made other rulings about, okay?
Okay, they don't want the jury to think that they're not willing to provide the boxes and boxes of evidence. I'm sure that there are in both of these.
I still think
But,
that the
I'll leave it to
defense
you.
should have at the
They
corner of their
wanna ask
table
this
the
witness
4-foot tall
questions about
stack of all the
Right.
messages
portions of this
as a
law.
visual
They don't want to show that.
visual
the jury
guide
keep
to
having
how
pages and
many
minutes.
messages we're talking about here.
I completely understand that. I get that. The other thing I would ask the court is until the exhibit is admitted, I would ask that the exhibits are not being published to the jury.
Yeah,
Because-
yes,
That's
correct,
fine. Yeah, that's fine.
Okay, well,
correct. Agreed.
okay, thank you.
Yeah.
So, I'm sorry, we're on exhibit.
Yes,
78.
yes, she
Okay,
did.
and
She was the defense attorney for Larry Nassar.
Let me just find
She's
the list
experienced
real quick.
in a bunch of other
In
cases. too.
78, we have
She
no
knows what she's
objection
doing.
to.
Okay, yeah.
And
With the
Seven-
exhibit.
some people were criticizing her for being a little too whiny, unprofessional. I will say that I'm not a fan of her style. I am not, it's not the style that I would approach this case in, but I'm not her. She is knowledgeable in the law. I will say that, but she has a different style that I don't really, it doesn't resonate with me. And it's fine. I see about 50% of my chat like her style and the other half don't. But she is smart. She is knowledgeable. She knows what she's doing.
6 was admitted as well.
Yeah, just try to put the, tell us what the exhibit is prior to, so that she knows which one.
He's hangry and
I
she's
have
a little
76
HOA-ish.
submitted,
That's a good way to put it.
78 was admitted. The
Who's
prosecution
HOA-ish?
indicated They are skipping.
Homeowners Association, like the
posted
whiny
exhibit.
king.
Oh, yeah.
HOA.
HOA.
So,
Although
got
we have no objection to 77.
okay, so you don't object to 76 or 78, so they're admitted. Okay.
I'm going to turn your volume up just a touch.
Okay. Do you remember my question?
No, sir, I apologize.
I don't either.
Okay. All right. So this is Exhibit 78. It's been admitted. This is from the James and Jennifer Facebook message thread. Okay. So before we get into the content, we talked for a little bit before about deleted content, specifically a Facebook Messenger thread between two people.
Correct.
Okay. Now, in the course of your investigation, you came to learn that Jennifer Crumbley had a Facebook account
That's correct.
and that James Crumbley also had one.
That's correct.
Okay. Did you uncover this particular chat thread on Jennifer Crumbley's phone?
No.
Okay. How did you obtain it?
Through a search warrant to James Crumbley's account.
Okay. So if there is an actual chat history, in this case, a 2,000-page chat
Calls
history
for
between two
speculation.
people,
She's gonna-
it's not found
He's
on
going
the
to ask
device,
for a
but
speculative.
it's found on the server. What does that indicate to you?
That one person deleted it.
Okay. And in
That's
fact, Jennifer
speculation.
Crumbley had the Facebook Messenger app on her phone.
That's correct. She did.
Just this was deleted.
The chat thread, correct.
All right.
Sorry, we don't have your backcountry hillbilly accent, Jung.
78 is a few slides, so we'll go through it together. Okay, we have the date and time up there. We're going to start with March the 9th of 2021. We're going to backtrack a day to give it context, and then we're going to go through late winter, early spring of 2021. Okay. So before we get into this, is it fair to say that as an investigator who analyzes all this electronic and digital information, you're able to provide a digital footprint
Ooh,
for the
that's a
individuals
good
you're
question.
investigating?
That's
Danielle.
correct.
Okay, and that's the
I know,
goal of
I'm
your
sitting here
investigation,
thinking of
generally
one.
speaking.
Yes, sir.
Blue is who?
That is Jennifer.
That's Jennifer. Okay. So she wrote, leaving at 4 today, what time you done? And that was March 9th at 2:55 p.m.
Correct.
Okay, now it says UTC -5. What does that mean?
The UTC is, that people might know as GMT. It's where all time starts in Greenwich, and then it goes plus or minus depending on which way you go from that line. At that time of the year in March, we were -5 hours from the start of time. So if you add 5 hours, it would give you what the UTC actual time is on the Earth.
So when you see UTC minus a number, that indicates to us that that's real time.
That's correct. It's already been factored in. The software did that.
Perfect. Okay.
The software downloads things in a weird way, and this is essentially demonstrative, but no one's objecting to the text. It's the software system, the way it's produces, makes everything look kind of weird and wonky.
Okay. So March the 9th, you able to get an idea what James and Jennifer were doing and talking about in this conversation?
Yes, sir.
Okay. So she wrote, leaving at 4 today, what time you done? James wrote 5. He's in green.
Correct.
And we know that because that's his Facebook ID as well as his name that came with the Cellbrite reader.
Correct. Yes, sir.
Okay. And she wrote, okay, see you at 5:30.
Correct.
The only time I think I messaged my wife on Facebook is when I'm sending her links to Facebook stories.
And all the
that I
information
find
that
are
you
funny or
recovered,
something.
is it fair to say that James and Jennifer Crumbley communicated quite a bit through Facebook Messenger?
Yes, sir. They did.
And so the Facebook Messenger thread is substantially more so in volume and data.
They're going to be talking about their son very shortly, and this
That's
is
correct.
back in March of 2021. And so the state's going to say
346
that
March
this
9th.
is
Jennifer wrote,
proof
bring me
that-
socks for in a drink, LOL.
James and Jennifer
what did
knew
James
something
write?
was wrong
A
with
drink.
their son.
Nah.
Okay. Jennifer got myself a drink at 4:31 p.m. And James's response,
Okay. You grab smokes too. Almost out, I think.
okay. And she writes, yes. Did you check the front porch? And what did James write?
Nothing on the porch. What were you expecting?
And she wrote their new blankets. Now, are you able to determine
And now you're here on YouTube.
where they go later that day?
Elegant News.
Yes, sir.
Okay, so need hoodie, NOL socks. I believe that was supposed to be wool. He wrote hoodie check. What are no socks on my way? Okay, now this is exhibit 79. Actually, I'm going to approach. Unless there's an objection to the photograph found on her phone.
I have no objection, but again, I would ask.
That's fine. That's fine.
Before they,
Yeah, I agree with you.
Thank you.
I agree with this.
but no objection to 79, thank you.
There are two exhibits on one side, so I'm going to.
Okay.
This is 79, and underneath it is 80. Have you seen those items before?
Yes, sir.
And how have you seen them?
There were pictures on Jennifer's phone.
Okay.
Thanks, Fox.
So I'm going to move to admit 79, I believe stipulation, as well as 80.
I'm sorry, can I have a moment, please?
Sure.
I have no objection to 79 or 80. That's correct.
79 is admitted and 80 is admitted.
Now, as an investigator, are you able to tell when you look at a photograph that's saved on a phone where the photograph was taken and when it was taken?
Potentially, yes, sir.
Potentially. Okay. And what circumstances?
If the camera is set to record, that you want it to tell you the date and time that it was taken and the GPS location of where you're at on the Earth.
Okay. So 79 and 80 on the screen. 79 is the picture itself. And then in the text box on the right, that's the metadata.
Correct.
What's metadata?
Metadata is, we call it, it's the data within the data. The main data here is a picture of the horse. The metadata inside that data is all the stuff, the camera make, the camera model. That's captured
Fedorovsky,
that you just don't usually ever know it happens.
or not Fedorovsky, Vielhammer. Can you confirm?
I think before we get into your investigation into the phones itself, I want us to back up a little bit and talk about your involvement, how you got involved in this case.
I'm not sure what my mother is asking
So,
me via text
November
message,
30th, 2021.
but it's a good question. Danielle, identify yourself.
Identify myself.
Yeah, who are you? What do you got going on? Danielle is a trial watcher from Florida. She is good friends with the wonderful and irreplaceable Steve Gosney, who is my senior court reporter in Florida and also a great public defense attorney and appellate attorney. And so she's a trial watcher, and she has decided to graciously join us here for today's trial. So
Thank
that's
you,
what she is.
David. That was wonderful. I couldn't have said it better.
You were a detective in computer crimes.
Yes, sir.
Okay. And do you remember that day?
Yes, sir.
Okay. Were you working?
Yes, sir.
Where were you at 12:51 p.m. on November the 30th?
At 12:51 p.m., I was sitting in my office, I believe, at the Oakland County Sheriff's Office.
Okay. Did you learn of the school shooting in Oxford?
Yes, sir.
Tell me how you learned that and what you did next.
Our captain came in, and well, prior to that, our sergeant, who was off that day, had said that there was a shooter at the high school, and we thought in the office like it was just somebody near the area that fired a long gun or something like that, from a house, and the police are gonna show up and do their job. And then probably a few minutes after that, our captain came in and said that there was a shooting at Oxford High School, and the phrase used was all hands on deck.
I'm not sure I agree with your statement here.
Being what is referred to
The last
as
part
a
of it
computer
anyways.
nerd, you just grab your stuff, your computer, your laptop, what you think you might need, what we had no idea what we were getting into. And I knew Oxford was a long ways away from the Pontiac area.
2 to 3
I
weeks is
figured by the time I
expected.
got there, it was going to be long over, and me and my partners are just going to do what we do.
Okay. So
That's what I was wondering,
have
John.
you get a squad?
Apparently, Jennifer kicked back a few glasses of wine and ordered a horse online. I don't know if that was this horse or not, or if she
Car,
owned
you know,
another
unmarked
horse prior
car.
to.
I have an unmarked, at the time I had an unmarked white minivan with emergency lights and siren in it.
So did you start heading north then?
Yes, sir.
All right, tell me about that.
I don't think so,
Oh.
John.
Well, at first it didn't seem real. I remember pulling out of the parking lot, and I looked to my
Officers
left,
crying
and there
out
was
in the
some patrol cars coming around the corner. There's the medical examiner's office down there, and I'm like, then it like really came real. Like, holy crap! Like they know about it. It was the state police. I'm like, they know about it. Like this is serious. It's bigger than I could ever have imagined. So I flipped my lights on at that point and just drove north
Okay. How fast were you going?
as fast as the van will let me.
How long did it take you to get there?
I have no idea. It seemed like eternity. I can tell you that much.
So Oxford High School, it's a large school. It's one level. It's one story rather.
Yes, sir.
As far as area, it's got a pretty big footprint. Okay. So where did you go when you pulled up?
When I was driving there, there's a lot of radio traffic, a lot. I remember I was actually at 24 and Lapeer Road, M24 Lapeer Road and Updike.
Did you hear
And they called that
the ATF
S1
guy
was in custody.
testified?
And I was still.
The ATF guy, this guy yesterday testified that when he got the call about the shooting, and he got out of his chair so fast it was probably still spinning as he was in this car. It's like, oh, he's a cartoon character. He's just incredible all the way around.
I know a ways off from there. But that, we didn't know what was going on. We didn't know if there was a second shooter, a third shooter, a bomb planted somewhere. So,
Yeah,
it
right.
just didn't stop. And I drove north on 24. It seemed like eternity. And with every half mile I drove, it seemed like there was another emergency vehicle falling in behind me.
Yesterday was described as a caravan. Would that be accurate?
Oh, it was definitely carried. There was one time I remember we were approaching a light, we were getting closer, and there was, the light had just turned red. So cross traffic was going to start, which obviously a dangerous situation, being in a car. Actually, the white minivan that no one believes is a police car And so as I approached, I got up into the intersection. I inched my way in there to stop traffic and hold the intersection. And I counted every vehicle that went past me, and there were 18 or SWAT trucks, ambulance, patrol cars from agencies that were nowhere even near our
I'm not
our
sure why
area.
this is relevant. They keep trying to bring everything
So
back
tell
to
me
the
what you
school
see
shooting as
when
much
you
as they
pull up
can.
on the
I
scene.
think to hit emotional.
Like I said, there's a lot of chatter on the radio. I wasn't familiar. I'm not familiar with the area of Oxford at the time. I had no idea where the school was. All I could hear was the staging area and Ray Road. And so I'm just thinking, I'm just going to drive north. I'm going to follow this caravan. We're going to go up there. And as soon as I see the Meyer, I'm going to stop there because I have no idea where the heck I'm going. I didn't bother putting in my GPS, of course. And I turn onto Ray Road, and all I see is
Yeah, what does it have to do with Jennifer?
I see kids at.
I know
Look
what
like
they're
my
doing.
kid.
I know what they're doing. Okay. Everyone gets the call. Everyone rushes over. They're all in a frenzy. And Jennifer is just hanging out at work. She's not going to the school. That's what they're going to do here.
Yeah, painting that
That's-
picture.
That's exactly where they're going with this. Right? Don't you think?
Oh, definitely.
There were girls wearing real, small clothing, and one kid, I didn't have a shoe on. They were coming down the road, coming towards the Meyer, and just like walking across the snow. And I remember it was cold that day. I had 2 coats on, and I was shaking when I got out of my car. And there's kids just walking past me, dressed like anybody in this courtroom is right now, they're not ready for the weather.
So you said you went to the Meyer on Ray Road.
Yes.
Did you learn that was the reunification point for parents and children?
At the time, I didn't know that was a reunification point. I just saw that there were a ton of kids going there. When I got out of my car, walked down there. They were sending everybody down to the garden area to try to get, the names of people that had gotten to that point. And once I got, that would be at the south end of the Myers. Once I got to the garden area, there were kids just everywhere, just standing.
How is this I make up whole thing
making
up?
their way into the.
Okay. What did you do when you arrived? Where did you go?
Like I said, I went to the garden area. I picked up on what they were trying to do. They were passing out notebooks just to write down everybody's names and phone number, all the students that were coming in. So I first started just collecting that. And then they started telling everybody, we got to go outside and get all the kids inside because again, it was freezing out there. And so I go back outside and I start like trying to direct people like to go
Did he
inside.
say
and
Myers?
know the trauma they just experienced. So I'm not gonna force them in the building. I'm not gonna grab them and drag them in there. And I remember putting my arm on a couple of the kids' shoulders and like they didn't move, they didn't nudge, they didn't do anything. There were parents there just standing there. There were some parents that had made it reunified with their kids. I remember seeing school buses pull up.
School buses with who?
Students on it that had made it out of the school.
Did you go to the school?
Yes, I was probably at the Meyer for like 15 minutes maybe. And then Detective Jeff Enger had called me and said that he was attempting to obtain the security footage from the school.
Where does Jeff Enger work?
He's also a detective in the computer crimes unit, worked with me.
So you were asked to go to the school?
Yes, sir.
Why were you asked to go there?
At that time, I was a little more versed in DVR systems. Jeff had told me, Detective Enger had told me that he was looking to trying to get that off of there, and he just didn't,
Meyer is a shopping center. I would say it's between the level of a Walmart and a Target.
Oh yeah, I've heard of
It's-
those.
Yeah, but it's a local, it's regional, it's Midwest. I think I don't think it goes much beyond Midwest, but yeah, it's the quality of stuff is between like a Walmart and a Target. Less than Target, more than Walmart.
want to get it right, of course. And so he asked me to come up there and help him.
So you drove to the high school from Meyer, or did you walk?
I drove.
It is better than
And
Target.
Where did you
Okay.
go when you got there?
Might be better than Target.
I drove to what would have been the north entrance of the school.
The main entrance?
Yes, the main
Okay.
entrance.
And tell me what you saw when you walked in.
When I first walked in,
Hey,
There's
Flux,
vehicles
welcome.
I mean, people walking in and coming in and out, crazy chaos. And I walk in and detectives or Sergeant Sean Wilson was standing at the door, keeping security, so to speak, you know, at the time, making sure people aren't coming in that shouldn't be there.
Okay. And where did you go?
I asked where this security office was, because that's where Detective Anger told me he was. And people pointed me, eventually it was back behind the main office.
Okay. So tell me what you did when you arrived and who was there.
Jim
Are you
Work
guys
was there.
feeling
who
any
was
of
the school
this
security
is
at the time.
helping with the case?
He was trying to get the video footage. Detective Jeff Egger was in the room. Sergeant Marsban, Lieutenant Marsban was in the room.
It's a good
Deputy
question,
Lewis, who was a
Mother.
school resource officer, was in the room. And ATF agent was also in the room.
That was Mr. Brandon?
Yes, exactly, yes.
Special agent, not Mr., I'm sorry.
Yes.
Did you know him at the time?
I had no idea who he was.
Okay. And you said you had a familiarity with DVR systems, that's why you were called.
Correct, yes,
You
sir.
can pull this
So
up.
what was your specific role?
Is any
as
of this
part
helping you
investigation?
towards the guilt or determining the guilt of the defendant?
I'll be honest, I wasn't given a direct mission or anything at that time, because they were looking for a second bad guy or third bad guy. And so I knew that people would want to know, the bosses would want to know what happened, like where did it start? Who was it if they didn't know that, or were there more people or whatever? So we just starting to look for the shooter in the hallway that it started.
Yeah, they can object, and the objection is relevancy. Objection, relevancy. What does this have to do with the case at hand? I'm not sure why they're not. Maybe they know why it's relevant. Maybe they know that the angle is that they're going to say everyone was concerned but Jennifer, and then therefore it would be relevant, and you don't want the state to have an opportunity to make that argument right now in front of the jury. So if she objects as to relevancy, then the prosecutor is going to say, well, it's relevant because it shows how everyone else responded but Jen. And you don't want that out there in front of the jury. So that's probably a reason why you don't object.
Was the school made safe at that point? They were still clearing the school?
No, it was not.
Okay. So the officers were still conducting their searches, 'cause like you said, they weren't sure if it was one shooter, two shooter, three
Yeah,
shooters.
it might have been, I'm sorry.
Oh, it could also be
It
used
might
to
have
introduce
been
video of the shooting. That's
1:30,
potential.
1:45 at this time, maybe a little bit later than that,
Okay. That's the time you arrived at the school?
and got to the office, correct?
Got
yes,
to the
sir.
office. Okay, thank you. Did you learn how many surveillance cameras were active in Oxford High School on November the 30th of 21?
Yes, there's
Just a
well over 90 of them.
Okay. And so it was your job at that point.
Donatarian.
Oh,
Identify
Donatarian. I'm sorry. Oh, yeah, that's
who the shooter
pronounced
was.
Donatarian.
Correct.
Okay, so how did you go about doing that?
We started in the hallway, the 200 hallway where it all started, in the bathroom that the shooter came out. And we attempted to backtrack him going in there. I remember it took us like 15 minutes to try to figure out, because he had actually changed his clothes. We didn't know who the shooter was. We didn't know his name in the office at that time. He was in custody at the time.
Because it makes her look
And
bad.
I remember someone in the office, someone saying, eventually giving us his name, and then saying that he was in the school counselor's office earlier that day. So we went back to that time of day when he was going in and out of the school counseling office to find out what he was actually wearing at that time. And we were able to follow him to the bathroom then.
How long did that process take you?
Well, because we didn't know what he was wearing, it took us 20 minutes to try to figure that out.
Now, are you the person, so you backtrack to the point where the shooter walked into the bathroom that he emerged from to begin the shooting, is that right?
Correct, yes,
Oh,
sir.
that's right, Aaron.
So are you the
I don't know. I
person, the
can't see what it
investigator
is.
who actually put together the footage of the shooting itself?
Yes, sir.
So you're familiar with the path the shooter took in the school?
Very much so, yes.
I'm going to ask you to walk us through that.
No, I don't think the
you
jury
said-
is bored
you
with
told
this.
us that he went into a bathroom.
I think the jury is going to be
It's a
very
bathroom
interested to
adjacent
hear
to
about what
258.
happened at the shooting.
Correct, yes.
Presuming they haven't watched like all the Miller hearing and all the Ethan Crumbley sentencing and all of this stuff, which they shouldn't be on the jury if they have. This is the first time they're really hearing about the details of this. So I think they're interested in it.
Tell us what happens next.
He comes out of the bathroom. What I envision is he comes out of the bathroom with a proud chest, with his
What I
Almost like
envision
his shoulders
is he
were
comes
back,
out of
like
the
he's-
bathroom and looks like this.
He looked excited. He comes out of the bathroom, and immediately to his left is a victim, and he shoots her in her neck, and then her boyfriend was there and shot him in his. He put his hand up and shot him in his mouth.
That's right outside 258.
Yes, sir.
What happened next?
He then quickly turned his gun to a group of 4 girls that were just standing there. He shot Hannah St. Julian, and she immediately fell to the ground. And then he continued shooting in the area that those girls were.
Yeah, they're definitely going to play
and
this
they
video.
sort of just like fell on top.
They're going to
of
play
each
the
other,
video of the shooting.
you know, because they were
Which
fit
again,
as well.
no one is contesting that the shooting happened, that Ethan did it,
You can use this to distract.
and that he did it with the gun
fine.
that was purchased by James. But the state is insisting on producing these videos.
At this point, it's under a minute that all that shooting happened. And then, so at that point, obviously it must have really, again, kicked in, for lack of a better phrase, to the victims in the hallway, and they started running. Then the shooter, with just a one-arm grab, just started firing rounds down the hallway, with no regard for obviously anything, and bullets are flying, and there was.
Is that what he meant by this? Or did he meant walking in all cocksure? Is that what he meant, Jung? See, this is the problem with words and your body language expertise. Is it doesn't always line up with other people's, perceptions. Because I heard like he walked in sort of like a sweat with some suasion and all cocksure, right? That's what I was depicting. Not that he was holding his breath. I don't know. Danielle, thoughts? Well, she froze. We'll come back to her. I think she lost power, actually.
There's one girl.
I'm just going to
who
pull
was,
her down for a
you
second
see at the end of
because
the
she gets
hallway.
back on here.
She just, as the shooting starts, she drops down into the fetal position in an attempt to protect herself. And the shooter runs
Froze,
up
but she looks fabulous.
to her
Can't bring her
and
back up.
just puts the gun right to her head. And that was Madison. And you see her fall over. He then goes around the hallway. And there's, at this time, all the kids have gotten out of the area, most of the kids. You see 2 girls. One stops at a classroom that obviously the victims inside have already locked the door, so you can't pull it open. You see her trying to tug on that door. And there's another girl with dark hair that comes running up behind her and like grabs her while the shooter is just shooting down the hallway. And then they just take off running further down the hallway.
It's from the Treehouse murder
Now
trial.
he's rounded the corner from where it all started.
But yes, that means the same.
Continues going down the hallway. I think he, at that point, he might have reloaded his gun and continued down the hallway. I'm sorry. And then he stops as he gets to, like, there's a courtyard, what they call the cubby. Jim worked on, they call this area the cubby, where the cameras are. And you see Tate Muir, he comes in the door and then just takes a left. He must not have known what was going on. And that's when the shooter leveled the gun, like if you were at a gun range and practicing. Leveled the gun, appeared to look down the sights of the gun, and fired around. Tate just fell instantly. He continues on down the hallway.
He's testifying to what he watched in a video. And I'm wondering if he's testifying in such detail because they're setting him up and then they're going to play the video, I think is what's going to happen. Danielle, hopefully we'll be back with us.
Walks past Tate. Doesn't care to acknowledge the fact that
Well,
even happened.
Shoot.
I'm
That's
sorry.
just going so quick.
Prior to walking down the hallway, that's right. He
They have to establish
Tate's
that a
body was
crime
laying
was
there.
committed.
you see the shooter
Even though
with the
everyone's
gun still
stipulated
level
to.
fires another round, and it causes Tate's body to jerk.
Yeah, he broke
I
its
don't know if
system.
he hit him in the hip or the backside or whatever. Tate's body jerks, and then the shooter walks past him. You see his feet at the top of the camera frame. There's not a camera that picks him up because they don't.
Hey, you're
they're not
back.
moving. They
I
don't-
lost
it's not
power for a
recording.
minute.
But you see his
I was gonna say your light, you smiled, and then your light turned off, and then you froze, and I was like, she lost power.
I did. Sorry about that.
No worries. Welcome back. I don't remember the question I asked you, but oh yeah, no, I can't remember. Oh, it's about the Swayzer.
Yeah.
feet stop
Okay.
in what I like.
No, what were you gonna say?
Was he referring to the
He was
kid?
saying when Ethan came out of the bathroom,
Ethan. Yeah.
he expected him to have a proud chest, and we were debating as to what proud chest meant, because in my mind, I meant he was walking out, with the Swayzer that one have, in the
Yeah.
action movies, and then Jung said it means like he's holding his breath or something, but that's, I was like, that's the problem with these things is trying to describe something. Just, I don't know why they're doing this anyways. This isn't relevant, or it is relevant. They have to establish that the crime happened, right? The state does have to do that. That is an element to this, but everyone has stipulated to it. So the state technically doesn't have to produce any of this evidence, but they want to, because it ties everybody in emotionally, and they want the jury responding emotionally, because that's what the state does. So anyways, did you have a thought on proud chest, what it meant?
No.
Later found out to be
I'll get back to you.
a teacher's classroom, and he turns.
You're still thinking about
and
that
he
punk
fires
rock
into that
song, right?
classroom.
Yeah.
He continues on down the hallway, looking into classrooms and stuff like that. There was one, as he gets so far down the hallway, he fired a couple rounds down the hallway. Once he gets to a certain point, all the children are gone at this point. The teachers had gotten him out of there and ran, out of the building and out through the door, wherever the heck they could get out of there. As he's coming back, you see him stop because the way that classroom was.
Morning, I am Dave.
if
I am
you're
also
walking
Dave.
Away from it, it's on your right-hand side.
You are
don't see the
absolutely allowed to
classroom
have
because it's
opinions
actually
here.
behind you at this point. But as he's
Even if
coming
they
back,
don't agree with
he
you.
must have seen people hiding in a corner because he can now see through the window, and he fires off a few rounds through that window. He keeps coming down. He's coming back down the hallway now at this point. And then
It's clear that
the
Ethan
assistant
reloaded
principal, Gibson Marshall,
at least
I didn't
twice.
know her at the time.
Or went through two
walks right past
magazines
her.
at least, maybe
And sort of,
part of a third.
I don't know what she said to him, but if she said anything, but you see like the shooter as he's walking by and the gun's in his hand, and he sort of just turns his head and just, I don't know why, but he turns his head and looks away from her, doesn't even look at her, doesn't acknowledge her after as he's walking past. And then he continues on down the hallway.
Yeah, I noticed that, Neil. Dark
and
Matter.
stops at the bathroom where Justin was killed. And just like an abrupt stop, like, okay, well, and he just turned right and went to the bathroom.
Dave,
So-
I am Dave. I love disagreements.
I didn't tell you I was going to ask you that. You obviously have this committed to memory.
Yes.
How many times have you seen this footage?
Like
And
said
I only
before,
allow
it's-
personal
I don't know,
attacks
it's burned in
against
my brain.
me.
And it was your responsibility to obtain that footage, to get the information to officials at the sheriff's office and federal law enforcement as well.
Yes, sir.
So you were the person that had to watch, rewind over and over again.
Countless times, yes.
Judge, this might be a good time for a short break.
Okay.
This was not prepared.
Your Honor, my client could use a second if we could, please. She's like, I'm trying to like,
Okay,
we could.
okay, I understand. We
Thank you.
understand. Okay,
Jamie,
so-
I don't know why I didn't send you a link. I'm sending you a link now.
Right, so if
Yay.
you're ready to use that for Sergeant, I'm in the habit of demoting and promoting.
So now that I've announced it publicly,
No, ma'am,
you have to get up here.
analyst now. I'm civilian employee, I'm
Oh, you're a
sorry.
civilian.
I'm sorry, ma'am.
Aw.
Okay.
Yes, sir, ma'am.
You are still a witness and still under oath, so you can't discuss your testimony with anyone during the break.
Yes, ma'am.
Okay?
Yes,
All
ma'am.
right.
He's a civilian analyst working for the U.S. Secret Service now, but he was an Oakland County detective or sheriff's detective at the time. I'm just gonna hear if there's any like little weird arguments and stuff after the jury is out, and then we'll fast forward and we'll get up to live. Yeah, I'm a homeless internet attorney that used to operate out of a treehouse until I was evicted from it.
You can take it downstairs. You can be seated.
Oh,
We should call the defense attorney Becky. Why? Because of her hair. Flux, what are your thoughts on that? I think somebody told her that we can hear all the conversations between her and her client because now she's
whispering.
whispering into her client's ear. We could hear everything. And one of the directions that the defense counsel gave to her client early yesterday morning was, remember, try not to show emotion, don't emote, just try to sit there, because that was the direction of the court. The court said, don't emote, don't grimace, don't be rolling your eyes, don't be doing stuff like that. And then when everyone started crying, and I mean everyone, including the state's witness on the stand yesterday during some of these videos, then Karen, the prosecutor, decided to address it and create an issue about the defendant and the defense counsel apparently crying during one of the videos. So you're damned if you do and you're damned if you don't. If you don't cry, then you're heartless and soulless. See, I'm heartless and soulless because I think I could watch that and not cry. But then I'm heartless and soulless. So it's like, but then I'm going to get emotional by watching it, and oh, well, then you're just a crybaby.
Yeah,
And
I didn't see that part. What were they watching? What kind of videos?
It was a video of Ethan had been approached by the assistant principal, and she approached him and said, "Hey, come this way. There's a school shooter." And then Ethan like stopped and looked at her, and then turned away, and then she realized that he was in fact the shooter.
Okay.
And then walked the other way, and then she went and assisted one of the victims that was lying on the ground that Ethan had just shot, and he, I believe, is one of the ones that died. And so the defendant is watching a video of her son doing these heinous things for the first time. She's watching this video and she breaks down crying.
Of course she's gonna react,
right? But this was a big deal for the prosecutor. And I know we keep calling her Karen. Her legal name is Karen. We're not calling her a Karen. Her name is Karen.
I was wondering about that.
Yeah, no, her name is Karen. So Dave likes to think he's heartless and soulless. But his zodiac sign, you better not reveal my zodiac sign. I have a thing out there. So not because I care if people know, but I want to know what zodiac sign I fit into. And I want to see if you guys get it right. So that's a little competition coming up. So anyone who thinks they have a finger on me with that, let me know.
Oh, I'll have to think about that too. That's funny.
So let's just get caught up live here. It doesn't look like they're doing anything. Everyone's shuffling back in. Still no volume. I don't want to. What do you guys think of the courtroom? All right, we are live again. So what's nice about these little breaks? We can get behind and then get caught up.
Right.
Fingering you. Yes. Did I phrase it right?
Fingering? Is that what it is?
Yeah. Scorpio. Someone said Scorpio, Virgo. You guys you're just gonna go through the whole thing. Taurus. You're listing 3 more zodiac signs. No, that was brought up during Baker's stream, I think, or somebody's birthday stream. And I said I'm not telling you what mine is. You guys all have to guess. We'll see what you guys actually think. I'm missing my Lions hat. I looked all over this morning for my Lions hat. I have 2 of them in the house, and I cannot find either one. One's my daughter's, and one is mine, and I cannot find them. And I'm disappointed because I wanted to wear it for today. It's the Friday before they dominate the 49ers on Sunday and head to the Super Bowl. So I'm really excited about that. Dave is probably a Leo. Probably. Why? What are the characteristics of a Leo that makes you think I'm a Leo? That's a Cancer. Composer, he, that's Cancer. Okay. Why am I a Leo? Yeah, go Lions, everybody. All right. So hang on. Someone was asking about the jury makeup. I'm trying to get back up there. Okay. So the jury is 17 jurors. There's there's 5 alternates. 10 of them are women, 7 are men. There is 1 black man. Otherwise, everyone is white. Most of them are parents. They are okay with guns. They go hunting. And they do not claim to have an opinion one way or other regarding Jennifer until they see the evidence. There is 1 woman I wrote down is a veterinarian. I'm not a fan of her. She owns a gun. She's a former police officer. She owns her gun for personal protection. But she said when she thinks of this case, she gets enraged. That was a big negative thing that she said, but I could tell that she was treating this very emotionally, which is not someone I would want on the jury. So I was thinking the defense would strike her, but they didn't. For whatever reason, they didn't strike her. She's my little nervous one. She's the one that I'd be nervous about as a defense attorney being on the stand. But many of them also agreed, the jurors meeting, also agreed that teens are sneaky. They can get a lot of things past their parents, and it's almost impossible for a parent to know everything that exists on a child's phone. So that's the makeup of the jury. I am Shout. Okay, I am Shout. Just became a member.
Nice.
Awesome. Thank you very much. Welcome. If you guys are new members or I am Shout, check out my member tab, which will take you to a link to my Discord, where I have a lot of things involving this case. I have a lot of the exhibits from yesterday, some clips. I also have some documents and motions that were filed in this case. My notes from yesterday are already up there on Discord. And then this morning I posted sort of the legal breakdown of the manslaughter charges. There's also the jury instructions. So if you want to look at the elements that the state would have to prove here, those are in Discord as well. So as well as a bunch of stuff on all the other cases that I cover are all in my Discord. All right, now we're back.
I apologize. So I'll start here. Ready for the jury?
Yes, Judge.
Yes, Judge. Thank you.
Ethan is an only child between James and Jennifer, but I believe James has 2 other kids with an ex in Florida. I believe. I'm not positive on that. So he has half siblings, but no full siblings.
There's your guy over there.
What? Oh,
The
there
guy.
he is.
Yeah.
Creepy dude. He's so creepy. Look at him. He's just creepy looking.
Mm-hmm. Gormy looking.
I want to know how many bodies are buried in his basement.
He looks like a lizard.
Oh, the dumpster defenders. Those guys were great. Wait, hang on. Do I have any of them?
I doubt it.
Those guys.
I doubt it.
Cindy Lou with the 999 super chat. I say also because Leos are known for their generosity of time, energy, respect, and money. As a result, Leos are attracted to others. I don't like others. Leos have a sense of self-assurance. Yeah, but I don't like others. See, so I fail on that one. I don't people well. This is the most peopling I do. I'm more outgoing on YouTube than anywhere else in my life.
Okay.
I don't do people.
Yeah, Farrell's like, yeah.
Now,
That's
just
not
one
Dave
more
at all.
question about November the 30th. When you arrived at the Meyer and Ray Road, were there just a few parents there or a lot of parents there?
There are dozens of.
Yeah,
parents
see,
just standing
that's
there
where they're
just waiting.
going. Parents
Now,
everywhere.
I want to
That's
direct your
Jennifer's
attention
missing.
now to the late winter of 2021 and the early spring of 2021. Specifically, how you came to know about information regarding that time period in your review of the defendant's device. So I had already introduced this exhibit 79 is the photograph, 80 is the metadata. Okay, and if you could tell us, did you recover evidence around this time frame that was of note to you of an investigator in this case?
Yes,
Okay, so like I said, we're going to start with March the 9th and move backwards from there.
That wasn't a leading question, but it was sure like a wink and a nod. Remember, when I ask you this is what I'm asking about.
Sir, I've just handed you a map. We were talking about metadata and how it can occasionally give an investigator an idea of where and when a photograph was taken.
Correct.
Okay, and if we look at the screen here on Exhibit 80, we have coordinates at the bottom of that metadata. Is that correct?
that's correct.
Okay, and so 81 I've just handed you, that's the coordinates plugged into a map.
Yeah, in a good, yes, correct.
People move to omit 81.
No objection.
81's
I'm
a-
sorry, 80,
It's a Google map of metadata.
yep, no objection.
81 is omitted.
So this is 81 on the screen here. And that tells you, in addition to the metadata, where the picture was taken, where that device was when the picture was taken.
Correct,
Okay, and again, this is March 9th of 2020.
correct.
Okay. Okay, now I'm going to ask you about
What?
Jennifer's son was texting Jennifer about on March 9th,
Oh,
2021.
No,
May I first
no,
witness?
you can't pay to
This is
learn.
People's Proposed Exhibit 82. Sir, those are text messages exported from Jennifer Crumbley's phone. Have you seen that in the past?
Yes, sir, I have.
Okay, and how did you come to see that?
From the phone extraction,
Okay, and you extracted the information, you reviewed those messages?
correct, yes.
People moved to omit 82.
Wait, but what time is this? He just said that this shows the location of the phone, but when and where? Where's the context for this exhibit?
Remember that?
82 is the text message between Shooter and Jennifer, pages 105, 106, dated March 9th, 2021.
Yeah, I believe that the court, I've previously
Previously
done.
lodged an
Thank you.
objection that I ruled on. Correct. It's
Admitted over objection.
82 is admitted.
Thank you. Sir, I'm going to publish that because there's multiple slides and then you can look at the screen.
No, these are not the demons
So
text.
this information
This is
is from
Jennifer to
Jennifer's
Ethan.
original phone. Is that right?
Correct.
Okay. And so People's 82, we have multiple slides here. The blue is the defendant's son. Is that correct?
Correct.
Okay. And what is he writing?
Oh, these are- I'm sorry, these are the demon-
7:50 in the evening.
These are the demons.
He's asking if Jennifer could come home. There's someone in the house, I think.
Okay. And what's the next text he writes?
It's, the third one says, someone walked into the bathroom and flushed the toilet and left the light on.
Okay. That's March 9th, 2021 at 7:50.
Correct, yes, sir.
Okay. And then March 9th, 7:50 and 52 seconds. What does he write?
And I thought it was you, but when I came out, no one was home.
And then he writes, there's no one in the house though.
Correct,
Dude, my door just slammed. That's at 8 p.m.
yes,
Maybe it's just my paranoia. That's at 8:01 p.m. March the 9th.
yes.
Okay. And then this is 8:01 p.m. text to his mother, the defendant, but when are you going to get home? And when was the next text response in the phone download that you recovered?
The next response was the following day on March 10th, where she said, where's your dad? At 10 a.m., 10:21 a.m.
May I approach the witness? This is People's Proposed Exhibit 83. Sir, take a look at that and tell me if you recognize it as handed you.
Yes, sir.
And how do you recognize that?
It's an extraction report in a PDF format of a call log from a cell phone.
Okay, and that call log specifically was recovered on the shooter's phone.
Good question,
Correct.
John.
Okay, this is from March 9th, 2021 to March the 20th, 2021.
That's on the last page. Yes, correct.
Okay, thank you. People move to admit 83.
And I have no objection to that.
83 is admitted.
So the slide I'm going to show you, it's a snippet of that. We're going to go back to Exhibit 83 throughout your testimony.
Okay.
Specifically, because we're talking about March the 9th right now. March the 9th, 2021, the phone call to either his mom or dad, to his father, James Crumbley. It was a missed call at 7:31 a.m. Is that right?
That's correct, yes.
And his mom called him at 8:38 p.m., March the 9th. I'm sorry, March the 10th.
Correct, on the 10th.
Okay, so the time those text messages were being sent to his mother, there were no phone calls or texts back in that relevant time period.
Correct.
Now, I'm going to back up a date.
What about
to March
Facebook
the 8th.
calling?
To give this context, may I approach a minute?
You could call through Facebook.
People's proposed
Sounds like they
exhibit
use
84.
Facebook a lot. Even with the horse trainer and like random people, they use
34
Facebook a lot.
is the portion
I didn't
of
know you
Facebook
could trace
thread
messages from
between James and Jennifer
Facebook
Crumbley.
Messenger.
He just
Yeah, you can make phone calls. My wife calls home to her parents in Sweden all the time on Facebook.
Oh
Messenger.
yeah, you could FaceTime and do all that, but I didn't know that you could like track messages from Facebook Messenger like they've done.
Well, this isn't Facebook Messenger. This is
The
well,
one
you
before
mean
that.
yeah, the actual messages, yes.
Yeah.
But this is just their cell phone, and they're saying, look, they made no phone call, and it's like, okay, well, what about? Look, they made no Facebook calls. Look, they had no Facebook messages. Look, there was no other communication. Like if they're trying to establish, like, he's home alone, he's scared that there's demons in there, and there's no further communication. This is why I say I think Jennifer might need to elaborate, testify and say, listen, Ethan, he liked the show Ghost Hunters, and he would watch scary movies and scare
Yeah,
himself.
it'd make him paranoid.
And it was like, yeah, I'm not going to respond to this because it's nonsense. I talked to him when I got home. Big deal. I've called the police before with strangers. Oh God. Okay. Well, don't listen to my mom.
386 of 388 from March the 8th of 21. Is that right?
Oh.
Correct.
And you've seen this before?
Yes, sir.
People move to admit 84.
No objection, Your Honor.
You don't ever talk to the police, mother.
So direct your attention to the screen.
Is that your mom in chat?
Yeah, that's my
This
mom.
is blue
Aw.
again is Jennifer, green is James. Is that right?
Correct.
Okay, and that's because this chat specifically was deleted from Jennifer's phone.
That's correct, it was.
Okay. So Jennifer's words, Ethan going to bowling. And what does James write?
IDK, I don't know.
Okay. And she writes, what do you mean IDK?
So this is removed.
His
She
response.
deleted some texts in March.
I don't know exactly what I said. We'll know after he gets home.
And
So
Jennifer
what?
wrote, does he have his phone? Why isn't he home yet? He should be home by now. That's March 8th, 21 at 3:12 p.m.
That's correct.
Okay. Then she writes, freaking out.
Wait a minute.
James
A kid was
responds,
supposed to be home by a certain time and didn't come home by that certain time. Well, that's a first. I have never heard of such a thing.
Right?
He does not get home until 3:16.
And then Jennifer wrote, I told you to pick him up because he's upset and I don't want him to do anything stupid, goddammit.
Correct.
That's March 8th, 21, 3:13 p.m.
That's correct.
Okay. And James writes, dude, chill. He is fine. I'm trying to fucking work.
That's correct, he did.
Okay. So for context, this is
That's like
the day
that line
before
say.
those text messages were sent by the defendant's son to the defendant.
Correct.
I want to move on to March the 17th of 2021. And approach the witness.
Sure.
This is people's proposed 85.
I know, right? So a text message was deleted at some point in the
85
past.
is the
Oh my
Facebook thread between James and Jennifer Crumbley, pages 432 to 435 from March 17th. Do you recognize that?
Yes, sir.
And how do you recognize it?
Again, it's a printout of a Facebook chat.
Yeah, doesn't this show, Haley, you bring up a good point. Doesn't this show that she's concerned about her son, where he's at and what he's
Absolutely.
doing? She's trying to stay on top of him. I don't want him to do anything dumb.
Okay. And you, of course,
They're
seen that
just
before.
inferring
Yes, because they're the
all
ones pulling
kinds of
information.
other
Correct.
meanings behind this.
85. People moved them in
My
85.
last two
Your Honor,
posts.
I'm trying to. pull it up.
Super chat, Jung, and I'll read them.
There you go.
I am Dave, extremely reasonable in my opinion. Okay.
It's hard. for
I will
me
block
to
whoever
determine
says something.
Your Honor, I
Which
believe.
exhibits have been subject to previous rulings, just so you know.
Thank you, Judge.
No,
Your
you
Honor,
won't.
I do object to 84 because there's portions of it that are not admissible, in my opinion.
84 is
I'm sorry, 85. I'm sorry, 85. There are portions of 85 that the defense objects to, and they have not been previously ruled upon by the court. May we approach?
Yes. You want to go in the hallway? I don't know.
The problem is the jurors
I
are
think
right up
first you
on
define
top
what
of
the
the
actual
judge.
objection is.
The
Because we have
objection,
a foundation to chain, we have a foundation to found, I'm sorry, we have a stipulation to chain in the foundation. He's already testified to a number of portions of this very same Facebook thread.
It's hard for me to know if I've seen this one before or if I know what it is.
this has not been the subject of a prior ruling.
Okay.
I object to portions of page 432.
Judge needs to
It
be
does
more
discuss a
considerate about
topic that has been ruled
doing
to
these
be
arguments
admissible.
outside the jury's
So I
presence.
am asking that those portions of 85 be struck. They're irrelevant.
Okay, can I see it?
May I approach?
Oh,
May I approach?
yeah, that may or may not help.
You have 85. Thank you.
By the way, while we have a little bit of a downtime, I will say that at noon, well, whenever we go on lunch break, I'm going to redirect you guys all over to the afternoon stream, but I'm also going to put in the chat as soon as I get it, whether a link to Laid Back Law with Eric Hunley. He's asked me to join. I said I'll join for a little bit if I can, give an update on this case over there, and then I'll be back over here as soon as the court comes back in session. So you'll be automatically redirected if you're watching on YouTube and you have redirect turned on to the afternoon stream. But then I'll also give you a link to Laid Back Law if you guys want to go over there, pop in for a minute, and then come back to the afternoon session. It usually goes from noon to 2 Eastern, so won't be able to stay there the whole time. It will conflict with this, but that's my plan for this afternoon. And at some point, maybe I'll eat something.
Yeah, make sure you eat something.
I got food. I got food for today, so that's good.
Nice.
Every time he speaks, he sounds more douchey. You talking about the prosecutor? Yeah, I'm not a fan of him. And I don't know if it's tainted because, well, I'm just not a fan of prosecutors, period. But I have a feeling if I saw him like at just a gathering, maybe he has that vibe. But the defense attorney, the other defense attorney, the guy there in the beard, I like him. He's very nice. I was chit-chatting with him in the cafeteria on Tuesday. Not about anything with the case, just
Small talk.
Small talk, yeah.
Yeah.
Yeah, Jennifer does get more than one outfit. I was concerned about that. Megan Amirowitz during her trial had to wear the same thing for like 6 days in a row, and I thought it
Gee.
prejudiced her, made her look bad.
You can step down if you want to. It's up to you.
Is it okay if I stay?
Yeah, you can step. Yeah, it's up to you. Most people don't want to stay seated there. So.
Oh, fine. Thank you.
All right. So an issue came up. I'm hoping that we're not going to have to.
That's true.
With every exhibit. So some of this I'm relying on memory. So a year and a half ago, some evidentiary rulings were made.
This trial is expected to last 2 to 3 weeks.
The fact that there was alcohol.
We have
alcohol in and of itself is not relevant.
And her husband's being tried separately, right?
yeah, his trial is expected to start in March. There's someone up at my door.
I'm listening, Judge.
What's your, okay, what's your?
He's just bringing you up to
Right
speed.
back.
There's room for me to-
Okay, all right, so, there was a ruling about,
Council moved to exclude certain pieces of evidence, and this court made a record that was June the 27th of 22.
Okay.
And in that record, actually it was page 40 of the transcript, the court specifically said, the court said that the court indicated that it was based upon a preliminary examination transcript. As the court recalls, neither party stipulated the exam transcript for the factual basis, and the court indicated that More evidence is being found even as we speak, I think. I don't want to paraphrase because that's not a verbatim quote.
Okay.
And in defense counsel's opening, so to bring the court up to speed on the record, counsel asked to approach and objected to any reference of alcohol. There's one text in this text message thread or Facebook thread between James and Jennifer. Jennifer on March 17th says, "Gonna get drunk and ride my horse." James responds, "Well, don't get drunk." They have a couple of more text messages in the midst of a conversation that is pertinent to our proofs. And that's because the next exhibit will be text messages from the school shooter to Jennifer Crumbley about seeing demons. And then there'll be evidence of a lack of phone calls, lack of text messages back. And to get back to the court's ruling, the court said no evidence of alcohol or substance use unless it does show some type of parental neglect.
Okay.
So these particular messages are the same time, the same date where the defendant's son is experiencing or stating that he's experiencing hallucinating. So this is all relevant.
And Your Honor, my point is on Exhibit 85, there are texts that do not need to be included to make the point that Mr. and Mrs. Crumbley were at the barn and not with their son. We're objecting to the texts that include buying beer, being drunk on a horse. They are irrelevant. They are also
did they remove the
irrelevant
jury?
to someone being a hypervigilant parent.
Oh no,
Did they escort the jury out?
I
hope
have
so.
no idea.
I had to step away. Can you get a DUI on a horse? No. You
Yeah,
can't get a
I
DUI
think
on a-
I heard that somebody has before. Maybe that was made
No,
up.
okay, so you can't operate a vehicle on a public road. So what you've heard probably is people like Amish operating a carriage drunk.
Yeah.
That you could get public intox being drunk on a horse, but you're not operating a vehicle.
Yeah,
'cause a
like
horse
people
is
that
not a
get
vehicle.
DUIs on tractors.
Yeah. But okay, I have to imagine they escorted the jury out.
Yeah,
I consider
probably.
myself
Curious
a
out, okay.
hypervigilant parent, and I have some cocktails once in a while. That issue
Well, don't
is
tell
not
people that.
relevant. The alcohol is not relevant. It's just an unnecessary part of this text to make them look like they're out drinking, when the whole point is that they're out with their horses and not with their son.
Judge, it's not counsel's idea of what the point is.
No, it's not just that they're out with their horses and not with their son, and there's no crime, there's obviously no crime committed by people with children having cocktails, and half this room would probably be in jail, but that being said, the issue is whether or not the shooter's texts are being ignored. That's the point of it.
Right, Judge. And there is an offer of proof. There's substantial evidence that has been excluded that shows the substance use of James and Jennifer Crumbley. Substantial. We're not introducing any of that because of the court's ruling. But directly in point to this, in the midst of a conversation, it is relevant. It's material, it's probative, it's under 401. People do know.
Okay, well, am I able to see a specific picture of, because some of it might be, some of it might not be. So I don't love to do this while the jury is waiting. Is there more things like this that?
The whole case is like this, Judge.
The shooter is having some trauma, feeling some trauma, and reaching out to the parents, and they're ignoring them. That evidence to me is obviously relevant.
Correct, Judge.
So,
See, and Ethan's not
I'm
going to
not objecting
testify,
to all of 85. I'm
which is
objecting to the
shitty
portions
because
about
now
alcohol.
he's
Okay.
forcing
Because
his
the door has
mother in
been
a
open.
position where she
Counsel
has to.
specifically said, I think more than once, that her client.
Yeah,
is
I drink in my
hypervigilant.
treehouse and I have kids.
That's-
Hang on. Nobody says anything about having a cocktail. But when
Welcome.
there's evidence to show that they are drinking when the son is texting things to the mother, no call back. That's important, and it's important to show the jury what they actually did and spent their time on.
okay, can I see the text right again? And is that the only one, because the jury's pulling their heels on that? Is there any more like this?
There are more like this. And
Okay, well, maybe we need to do this at 6 o'clock tonight. I should have been raised last night. Okay.
Judge, these exhibits were turned over a long time ago.
I know.
No. I got all these text messages a long time ago.
Okay.
I found out what they were planning to use from the boxes and boxes of information I found that
It's
out
ridiculous.
on, excuse me, on Tuesday night. Yeah, I've had this discovery, but I can't file a motion to exclude every single line of these things. I filed many motions. I filed a motion about the alcohol. This part of the text that they told me 2 days ago they're gonna use includes alcohol. I'm just asking that the alcohol portion be struck.
Okay, I understand that, but I know that there's a lot of exhibits. And I know there's a lot of documents, but we could have had a massive motion and limine fest a while ago, right? So I am loath to make the jury sit there while we're going line by line through evidence. That's very problematic to me.
I didn't intend for this issue to take
And
a long
I'm so
time. I
limited.
thought this would
Okay,
be a
new
simple
poll is up.
objection to just take out the
Wait,
text
no,
about
not yet.
drinking, and that's it.
Okay, so
Uh-huh.
she says, I'm gonna get drunk and ride my horse, okay, so that might not be specifically relevant, but
Right. The new poll is up. It's kind of choppy because I'm limited in characters.
at what time is he,
When she's on her horse, that's when he's texting her.
okay,
And just because she's on her horse and he's texting her, doesn't mean she's looking at the text and ignoring him and saying, I'm gonna have a drink instead of I mean,
okay, my understanding was there was a large period of time where he was texting her and she was with her horse. And
So the
then
new
he
poll
said-
is thoughts on attorneys.
Correct.
Defense is more of a Karen than
right, she's
Karen.
on
Prosecutor
you're
less of
gonna
a
hear
man than
testimony from
defense.
other witnesses that the cell phone signal doesn't work out where the horse place
Well, then
is.
that's argument for counsel to make.
It is.
Right, but the fact that they're having beers out there with the horses is not relevant to the point the prosecution's even trying to make about the fact that they're unavailable and not responding to their son.
Okay, there's a text from James Crumbley. This is not when I like to do this.
He says he's not happy about this case going longer than 2 to 3 weeks. There's 20 to 25 witnesses from the state side alone. She knows this is going to take forever. She does not want this to be a 6-week trial.
Okay, she says, gonna get drunk and ride my horse. That's at 1:30 in the afternoon. When do you say he's trying to contact her?
That was
A text message said, I'm going to get drunk and ride my horse. Sounds like something I would have said on a stream at 1:30 in the afternoon.
a day during the week when she was at work. After work, she went to the barn. The text being around 5:50 p.m. When she's at the barn, we know that from
Whiskey
pictures and metadata.
The $4.99 super chat. Thank you very much for the super chat. This starting to look like a railroading of the defendant. The male prosecutor has no professionalism. There's a lot of emotions, anger, frustration from the professionals in this room, and it's a little frustrating. It's kind of a little annoying to hear. This is my hometown, on display here, and I'm not happy with the lack of professionalism that I'm seeing. But it makes for good entertainment.
Okay,
Oh, yeah.
Hey, good morning, Dave. Yeah, geez.
Daddy T.
Huh?
Daddy T, I get drunk and ride my horses all the time, or my farm all the time. These comments are killing me.
And so the court is aware there are no other, we took all other reference out prior to trial of alcohol use in accordance with this court's order. Of course, that's subject to the door being open.
The door was not opened by me saying that she's a vigilant mother.
Did we start cross?
I don't think so.
They go to
Okay.
the barn after work. Is that correct? Do we know what time approximately they go to the barn? This text is at 1:30, right?
Those texts are from during the day when they're making plans to go to the.
I'll be
barn.
right back.
Right.
And then I
Wait,
believe.
that's what I asked.
Jamie, why are you
the
not on
text
panel
says
yet?
Something about.
Yeah,
using
Jamie?
You're
all-
streaming? Is it not my custody day? Did I get the calendar wrong?
Is text about demons.
At the same time,
Okay, but is that at 5 o'clock, 6 o'clock, 7 o'clock?
the first text, the house is on at 6:03 p.m.
Okay.
There's a picture of James on a horse taken by Jennifer. There's a picture of Jennifer on a
And
horse
no
at the same
objection.
time.
Okay, all right. So she says, I'm going to get drunk and ride my horse. That she's expressing her intention.
I want to make this into a song. I'm going to get drunk and ride my horse.
Text, but not the next one about, well, don't get drunk. We're definitely going to hit some drinks. We need to stop and get me a 12-pack of Budweiser bottles, please. I'm going to keep that out. All right. And all right, I'm going to keep that out.
Today is our day. Yeah. Okay, fair enough.
Go later,
Jimmy doesn't need to come on.
ride her horse, and get drunk. And when she's riding her horse, when she's at the barn later, is when he is texting and getting no response. So I think that could be relevant to her.
That's what I'm thinking. I'm going to use some chat GPT and write me a song about getting drunk and riding a horse. I'm going to do that right now.
Is there anything else in there?
Okay, so just for the record, page 432,
Yeah.
the second text or message
Yeah,
back from James Crumbley.
Is there anything else in there?
I'm looking out.
Yeah. Because I don't want to,
No,
we were making good headway yesterday. Now we're moving at a snail's pace. So.
Oh, I got to log in. Log me in.
well, Your Honor, there's also a text responding to the one about buying beers. Jennifer just says, okay, but glass is not a good idea. I mean,
Yeah, that you can strike that too, because it's referring to the text above. It's
Write me a song about getting drunk and riding
so it would
horses.
just be those two portions.
Okay, yeah, can you strike that? I don't know how easy it is to do it up here, but,
It'll just take a minute.
okay. All right. Are there any other issues such as this?
The saloon doors swing as I step inside. Whiskey flows on this wild ride. Singing songs of freedom in the open range. Tonight, we're cowboys ready for a change. Something like that. Drunk on dreams and whiskeys flow. This is actually not too bad. I want to put this in Discord.
It's funny.
Okay, exhibit 87, 88, 89,
This is great.
90, 91, 92.
I mean, we're trying on the fly to edit an exhibit
Okay, go
or an
ahead.
objection we just got, and now there's like,
Okay, I want to find out if there's any looming issues, because
we do too.
they're gonna get
because
their 10,000 steps here.
We do too.
Your Honor, I did not think this objection would be such a process. I simply was asking for like one little part of this to be struck, and
Okay,
objections during trial are common. This is
Okay.
just a very simple.
all right, but is there anything else coming up that would require the jury to step out of? There's photos.
Well,
I don't know what objections to such. What are the
I
photos?
have objections
Yeah,
to
Taylor
many
Swift.
photos that are gonna be brought in through a different witness, but what are they planning to use? Because I have 450 right now. If I know what's coming, I can tell the court.
Okay, well, there's a list of exhibits, and there's, coming up to that, after the text messages are pictures. It looks like there's pictures of James and Jennifer.
I put it under the Crumbley channel. And
I
just
just want to know if,
Your Honor, if I could just say, there's a lot of inquiry as to exactly who we're calling next, which exhibit we're, and, this isn't a math formula. We really are changing this organically because we're
I
working.
get it.
So we're trying to be cooperative, but things do change.
I know, and you're not required to divulge your trial strategy and your order and all that. I'm moving a lot of people around, and I just want to know if there's anything else that needs to be handled right now on the record.
The only other objections, I believe, with respect to this witness, at least for the next very long time, are objections the court's already ruled on. So,
Okay, thank you.
okay, so at least we can get through, this whole page of exhibits with no problem.
All right.
Jung with the
Perhaps counsel
199
can
super
meet
chat.
us
It
after
says
court
smash
today
that
to
like
go over
button,
the
y'all. I
proposed
agree with her.
exhibits, and then we can.
On a rare occasion, I agree with Jung.
Okay, yeah, it's just because I don't want to change your time.
That sounds great.
All right.
368 of you watching, 188
So
likes.
85 is modified and
You're
we're,
obviously here watching.
Yes.
thank you.
You must like it.
What am I gonna do?
The barn you used to keep your horse at the barn next door.
What am
I would get concerned if I was a little tipsy on a horse, but more experienced riders.
I-
I don't like when they zoom in on defendants' faces.
Yeah, it's invasive
With,
Mhm.
and it's just weird. Yeah.
Man, just hate watching. All right, fair enough. Hit the thumbs down then. It all helps the algorithm.
I do agree with all those.
Yeah.
Up through 100. Right, which is already proposed, and that'll be easy. And then I don't have any objections. I mean,
A true cowboy would ride his horse to the bar, get drunk, and then the horse would carry him home. There's stories like my great grandfather that would do that. The horse would put itself away in the barn, and then he'd either sleep out there, or my great grandmother would like walk him into the house or something.
Want to streamline it as much as possible.
Or it's just puts himself in the bar.
Yeah. Just walks him home and knows where he's going and puts him in the barn.
We're on exhibit 84, I think. All right. This is between James and Jennifer Crumbley. Again, Jennifer is in blue.
Sorry, did he say this is still exhibit 84? I thought we
James
were
is
on
in
85.
green. We'll start at the top because I don't recall where we left off. Does he have his phone from Jennifer, RCA?
I'm sorry, you said you're on exhibit 84, but I believe it's 85.
84 was admitted.
84 was admitted. Yes, because 85 is March 17th.
The 84 was on March 8th.
Okay, so you're on 80, I'm on 84, okay, but mine
84
was,
was on March 8th, and this one is on March.
This is 84 on the screen.
That's 84, yeah.
okay, I'm sorry,
He went
it
back.
scrolled down, so, okay, thank you.
Jung Min with the $4.99 super chat. Did you know David rewatches his own trials here with us? He is the prosecution and does, in fact, state what, if anything. Go watch. Yes, there is a channel or there's a playlist of MLS Goes to Court. I was not the prosecutor. I was the plaintiff's attorney. And I may have said what, if anything. I may have.
I watched that.
It was a good trial. It was fun. Oh, we got an outcome.
James
I got to do a
responds
stream
with
on it.
yes, but
We
he
can
won't
finally
answer
talk
while
about
he
it
is
now.
walking. I will let you know the minute he walks in.
Okay. Jennifer's response, I'm serious freaking out. Is he home yet? And then, okay, now we're moving on to 85. So James and Jennifer Facebook messages. This is from March 17th of 2021. And you've seen this before.
Yes, sir.
And this is admitted pursuant the order that we just had on the record, correct, Judge? Thank you. Okay, March 17, 2021, 1:23 p.m. Jennifer writes, cool, leaving at 4 today. Fuck this place. James's response is what?
LOL, you have your stuff for the barn?
Okay. And then Jennifer's response, yes. Gonna get drunk and ride my horse.
Gonna get
That's March
drunk and ride
17th,
my
2020,
horse.
1:30 p.m.
Correct.
There's a response back.
Jamie is in the
Then
green
what does
room.
James
Should I
say?
let her in?
James says, okay, when
Absolutely.
cans, you have the
She
debit
doesn't have a
card.
camera or her
Jennifer's
mic on.
response, I know, hate my
Hi,
job.
Jamie.
Can you bring out
Jamie.
last, please? He says yes.
Hi, guys.
Correct.
You want to sing the song I put in Discord?
You put it in Discord.
I did.
Of course you did.
I know I hate my job. Can you bring out?
Now, on that same day, you're finding text messages from Jennifer's son to her of a concerning nature. This is March 17, 2021.
Yes, sir.
Okay. This is People's Proposed 86. I don't believe we have an objection to this.
No objection, thank you.
This is 86.
86.
86 admitted.
Okay.
Jesus.
What does Jennifer's son write to her on March 17th, 2021 at 6:03 p.m.?
He says, okay, the house is now haunted.
And then what?
Some weird shit just happens and now I'm scared. Then it follows with, I got some videos.
Okay, Your Honor, I apologize. This was previously the subject of a motion. I do object, however, the court has already ruled it's admissible. I'm sorry, I misspoke.
Yes,
Okay.
yes, I have already ruled on this here.
Okay, sorry about
No,
that.
that's right.
Okay, please, at the top.
And then Ethan says, continues with.
I don't
"And a
think we ever
picture
see
of the
those
demon.
videos.
It's throwing bowls. The word bowls is in all caps. He then says, I am not joking. It fucked up the kitchen.
And the next message after that?
He says, I'm just going to be outsider for a while. Can you at least text back?
Okay, so that's from 6:03 to 6:29. The last text, you at least text back was 6:29 p.m.
Correct, yes.
Okay. And the next response from the defendant to her son is when?
2 days later, it's 4:11 in the afternoon. Where's your dad?
Well, Cindy, I was going to do a whole stream on it, but if
This
you
is
really want to
people's
know a spoiler,
87 and 80.
they got their domain and a $10,000 award, 10,000 and some change award. So it was a victory.
88. I don't believe there's an objection to either of these two exhibits.
Finally, telling us.
87 is the picture. 88 is the metadata
It's
with
only
the
been
picture.
6 months.
So
Yeah.
could you please tell us when and where this picture was taken?
It was taken, the GPS similar to the previous ones at a horse barn. He's on a horse. It was taken on March 17th at 6:03 p.m.
Okay, 6:03, that's the same time that the text message regarding the house being haunted and saw a demon?
Correct.
Okay. And this is actually found on Jennifer Crumbley's phone.
That's correct, it was.
And who's that a picture of?
That's James Crumbley.
And that's St. Patrick's Day, correct?
Correct.
This is exhibit 88 and, I'm sorry, 89 and 90. 89 is the photograph, 90 is the metadata.
And we have no objection to 88, 89, or 90.
Thank you. And this is also St. Patrick's.
Can you move for their admission before you put them on the screen?
Yes, sir.
Okay, thank you.
This is also St. Patrick's Day 2021. Is that correct?
Correct, same day.
And this is an image also on Jennifer Crumbley's phone.
Correct.
Okay. And when was this taken?
On March 17th at 6:03 p.m.
Okay. Same location?
It appears so, yes.
Now I'm going to move you on to exhibit 91 and exhibit 92. I don't believe there's an objection to either of these pieces of evidence.
There's no objection.
91 and 92 are admitted.
Thank you, Judge. Again, we're still talking about St. Patrick's Day 2021. What time was this picture taken?
This was taken at 6:28 in the evening.
Okay. And again, is that time and date significant to you as an investigator in this case?
Yes, it is.
Why?
It was a time when the shooter was sending the text messages.
Okay. And this is also on Jennifer Crumbley's phone.
Correct.
91 and 92.
Okay, we get it. They're out riding horses and he's sending text. They left them home alone.
93 and 94.
A 15-year-old.
Thank you, Judge.
I leave
For a
my
couple of hours.
15-year-old home alone all the time.
Exhibit
I
93.
know, right?
Also a picture
I don't have to work.
captured on Jennifer Crumbley's phone. This is also St. Patrick's Day 2021. And this
Yeah,
is
they're supposed to
6:30
neglect
p.m.
their horse for
Correct.
sure.
Same location as the other photographs we
It
just
appears so,
mentioned?
yes, sir.
Okay. I'm going to go back to exhibit 83. This has already been admitted. This is the phone log found on the shooter's phone. So the time we're speaking of, those text messages where he sent his mother indication that he was seeing bowls, flap, shelf, and the demon, that was between 6:03 p.m. and 6:29 p.m. Is that right?
That's correct.
Okay. So we already saw there
People,
was not a text back from Jennifer
Thanks to
Crumbley,
C-Sweat.
but tell us about the phone logs. What do these show?
It shows a phone call from Jennifer Crumbley at 7:24 p.m.
Okay.
You know, there is no testimony regarding receiving it. That's true, Mother. I can't remember the testimony regarding cell phone coverage.
So that's about an hour and a half after he texted about the house being haunted.
That's correct.
And that was a 19-second call?
Correct.
Okay. Now I'm going to move on to March the 19th, 2021. This is a Facebook conversation between James and Jennifer regarding their son that day. This is People's 95. I don't believe I have an objection to this.
No, there was no objection.
95 is admitted.
Thank you. Okay. Again, Jennifer in blue, James in green.
Correct.
I don't know the
Okay.
horse names. I don't
She
remember.
said, "Is he awake?" And what did James respond?
James responds with, yeah.
Jennifer wrote, "How is he?"
James then responds with, he woke up looking like he had way, in all caps, W-A-Y, too much to drink last night, complaining about a headache.
Okay. And then
Doesn't this seem to indicate that they had? This is the next day, by the way, right? So this is the 19th. So, well, there's 2 days in between. So the 17th is when Ethan is texting his mom. Weird shit is happening. They're at the horses. He took some video, blah, blah, blah. So then the 18th happens. And then the 19th, how is he doing? Sounds like a concerned mom. And also sounds like they had a conversation with him, right?
Right.
Her response as well, he was really worked up and out of control, so I can see why. That's March 19th, 21 at 9:41 a.m. About 48 seconds later, she wrote, all I know is he needs to eat, go to work, and work hard and not complain, and he can get his stuff back.
Correct.
And then March 19th later on, he responded and didn't get it. That's Jennifer Crumbley's words?
That's correct, yes.
Yes. Just you did have marked 95 down for admission, correct?
Yes, it's.
Thank you. Okay. Now, the next day, March the 20th, did you find text messages from the school shooter to his mother, the defendant, of a concerning nature from that day?
Yes.
This is exhibit
This
96.
is
I believe this is
slivers of
subject to
evidence from the
previous
forest
ruling.
of trees that the defense was talking about in opening statement.
No,
96.
25,000 messages. These are the few that they pulled out.
We're still on, I'm sorry, we're still on 95 on the slide. James wrote, Jesus, yes, he said,
These text messages are March 17th, 18th, 19th, and the shooting happened November 30th. Just for context.
referring to their son, let me ask you a question. Why am I in your guys' room? LOL. And Jennifer's response is what?
Okay.
OMG.
I'll check out
Oh my
your
God.
message on Discord. So, talking about taking Xanax, using melatonin, did he sleep better or did he seem
So
better?
just to make sure everybody's on the same page, this is exhibit 95. This is from March 19th, 2021. We
If
already
he's
gone
getting
through these.
Xanax, he's got to have a prescription for that. So, obviously, they took him to the
9:41
doctor,
a.m.
right?
When Jennifer wrote he
Yep.
was really worked up and out of control. In
Our
the same-
resident drug dealer, Jamie, do you need a prescription for Xanax?
You absolutely
Mhm.
do.
Yep.
Okay, there you go.
And usually a psychiatrist is what gives them to you. So
There we go.
text message conversation. There's no breaks in this exhibit.
When they go to publish the exhibit, they have to move to admit. Anytime that one side moves to admit an exhibit, they have to confer with the other side if there's an objection or not. If there's no objection, then it gets admitted. That's why they keep asking.
And the conversation continued. James wrote what?
I totally thought you were giving him a Xanax last night. ...
And Jennifer's response was,
Does he seem better?
and then,
No melatonin.
and James wrote what?
I know.
And Jennifer
Yeah,
wrote,
that's a good question.
But
Do
he
the
hasn't
parents
had
take
one before, so I
Xanax?
should have only given
Yeah.
him half.
I don't know.
and then James'
Because-
response is, he's doing
Is
it at
mel-
school
does-
'cause his
okay,
head
Jamie,
hurts.
to your knowledge, do you need a prescription for melatonin?
no. Oh,
No,
sorry.
you can get sorry, no. It's over the counter, yeah.
Okay. Jamie, for those of you who don't know, is our resident drug dealer, licensed drug dealer.
Resident
Legal
drug dealer. Oh,
Legal. I'm legal.
I go to the experts for the information.
He took Tylenol.
Correct.
Okay. And Jennifer's response was, is he okay to work? That's at March 19th at 11 a.m.
Correct.
And James's response,
Was yeah.
and that's
Yeah.
also, it's 11:13 a.m.
Correct.
Okay. And then Jennifer wrote 11:38 a.m. on March 19th. Does he remember what he did?
Correct.
Okay. And what was James's response?
James responds with, dude, I am working on a demo right now. I have not talked to him and he is doing school.
And then her response is,
Okay, then, geesh.
okay, thank you. And this is 96 that we just admitted. This is from March the 20th of 2021. And again, did you find text messages from the school shooter to the defendant of a concerning nature?
Correct.
Okay. In the blue, that's all the school shooter's words?
Correct.
Okay. What did he write to her?
He starts with, I finished picking up the room. That was at 2:38 on the 20th.
2:33?
2:33, I'm sorry,
Okay.
yes. He then says, I cleaned until the clothes started flying off the shelf.
And then what?
This stuff only happens when I'm home alone.
Okay, it's March 20th, 2021 at 2:34 p.m.
Correct.
And this is the same date and time?
Yes, it is.
And what did you write?
I picked the close back up though.
Okay, that's March 20th at 2:34.
Correct.
And when was the next response to that?
By Jennifer was on the 22nd of March at 8:17 p.m.
Okay, so I'm going back to Exhibit 83, which is the phone log found, recovered off of the school shooter's phone, specific to these days. Okay, so we just went through March the 20th, and those messages were sent about 2:30 in the afternoon, if you recall. Is that right?
Yes, sir.
Okay. And were there any phone calls in that time period?
No, there was not.
Okay.
Yeah, I feel like
That
it would be
next
more
call
likely
is
an
6.
excuse for a kid that like broke a bunch of stuff to say, "Oh, there was a ghost in the house," and try to get away with it. It sounds like the kid might be a little immature, but not that he's actually seeing ghosts.
37 p.m. on March the 20th.
Correct.
No objection. Oh, sorry, you can say the numbers and not say no objection.
97 and 98, Judge, I believe would be admitted.
We have no objection.
97 and 98 are admitted.
Thank you. So, sir, were we able to tell where James and Jennifer Crumbley were yet again on that day?
Yes, sir.
Okay. This is 97 and 98. 97 is the photograph, 98 the metadata. This is March 20th, 2021 at 1:51 p.m.
Correct.
Okay, and if you recall, the text messages from the school shooter were sent to his mother about 2:30 in the afternoon.
Correct.
Okay, so tell us where Jennifer and James Crumbley were at this date and time.
They're riding the horses again.
$99 and $100
No objection.
Is it 99?
and $100.
No objection to either one?
No objection to either one.
99 and 100 are admitted.
Thank you, Judge.
99.
Okay, now this was taken off of the last picture. Was taken off of James Crumbley's phone, 97, 98.
That's correct.
99 and 100 were taken off of Jennifer Crumbley's phone.
Correct.
Okay, so the capture time here, March 20th, 2021, 11:58 a.m.
That's correct.
Okay, so then that would indicate to you that they were at the barn at least from that period of time until at least 1:51 p.m.
Correct.
Okay.
What does it matter? What does this matter that they're at the barn with their horses? They're trying to say that
Sir, during the course of
they
your
went and saw their
investigation,
horses
did you come to learn that the school
while their
shooter
son
had
was being
only one
punished
friend?
and cleaning
Yes.
up a room.
And did you also learn that that individual was abruptly taken from the state of Michigan about a month before the shooting occurred?
Yes, he was.
This
And
is-
Talking
did
about the
you
friend.
review the text message thread between the school shooter and that other individual?
Yes.
See, this I have a problem with. So they're going to admit a text message string, not between the witness and somebody else, not between the witness and the friend or Ethan. You know, Ethan's not testifying, the friend's not testifying. This is an officer that's saying that this hearsay conversation is taking place. And they're going to admit this. This I have a problem with, fundamentally, from a rule of evidence hearsay point of view. I have a problem with
agree.
this. How are you going to cross-examine the friend who goes unnamed and is not being called to the stand? Or how do you cross-examine Ethan, who's not going to be called to the stand because he's going to plead the fifth? Nope, Ethan has not been diagnosed with anything, even after he was arrested and went through a bunch of psychological evaluations for the Miller hearing and everything else. To my knowledge, and nothing.
You looked at the entirety of the phone of the school shooter as well as James and Jennifer Crumbley's phone, is that right?
That's correct.
If you could give us an idea, the volume of the data found in the text message thread between the school shooter and his friend.
There was over 20,000 text messages just between the two people. I've
20,000.
done exams on phones where the combined number of text messages isn't that much.
So what's the relative size and data between that particular text message thread and any other thread between the school shooter and anybody else?
I think the most text between any other person might have been near 500, an individual person.
I'm going to show you a portion that's been previously admitted by this court of that text message thread from April the 4th of 2021, April the 5th of 2021. That's Exhibit 101.
And the court's previously ruled on this.
Not 100. Would have been good.
One of the ones admitted.
Thank you, Judge. So we have
100%. This is
redacted.
101% accurate, or whatever he said.
101 was found on the shooter's phone. Is that
100% correct.
That's correct.
Yeah, that's right.
So in this instance, then the green would be his words, the shooter's words.
Correct, yes.
Okay. Tell us what he wrote to his friend on April the 4th of 21.
The shooter wrote, like, I hear people talking to me and see someone in the distance, and then corrected the spelling of the word distance.
It's April 4th, 11:56.
Correct.
Okay.
Yeah.
What else?
The shooter said, I actually asked my dad to take him to the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
And then what?
He then says, like, it's at the point that I'm asking to go to the doctor. Then he says, my mom laughed when I told her.
So that's April 4th, 2021, 11:57 p.m. His words, my mom.
But here's the problem with admitting this. Do we know that those statements are true? Can we cross-examine these statements? Right? Every defendant has the right to confront the witnesses against them. If Ethan, for example, was on the stand and said, I told my parents I was seeing these things and I needed to go to the doctor and my mom laughed at me. Well, then you could cross-examine him and say, is that really what happened? Or was she on the phone with her friend? Or, something else was going on. Did they throw pills at you? What were these pills? What did they look like? Oh, they were baby aspirin. Okay. You can't cross-examine this. Did you really say this to your friend? Or were you just placating to him? What was the nature of the conversation you were having before this? Were you on your phone with your friend? Did you talk to him about this? Did you follow up with him? None of this cross-examination can happen now, yet they're admitting these documents. This is a huge problem for me just from a defendant's rights standpoint. Honestly, I don't know. The judge had ruled that under Rule 8031, which is a exception for present sense impression, which is usually what you use for writing down notes. I wrote down the license plate of a car as it was driving off, right? And you can admit that note, whatever. Things like that. Or at the time, this is what I was feeling. That's the present sense impression exception. And for some reason, the judge decided that that was good enough of an exception to get this in. But I still don't see how it alleviates the right of the defendant to cross-examine the witnesses against them. Because essentially, Ethan, right now, with these words, is a witness against his mother. But you can't cross-examine because he's pled the fifth. So the defense had filed the motion saying, then you can't introduce these things because my client has the right to cross-examine all the witnesses. Ethan's now a witness because of these statements, and she can't cross-examine him. So I see a huge problem with this. Cause an appeal? Yeah, if she gets convicted, absolutely. I feel like this should be overturned because of this. So yeah, she would need to be convicted and then it would be overturned. One of the two in the conversation for 8. Yeah, exactly. You do. Now, usually the biggest thing is like if Jennifer had responded and Ethan is on the stand and he says, my mom responded by saying this. Well, that's an out of court statement, but she's a party opponent, so it can be admitted. Usually you have to have one of the two people. You can't have this case is all about third parties, right? We have the intentional wrongful act of a third party, and we have a third party admitting a conversation between two unrelated people. This is a mess of an evidentiary issue. And welcome to the pre-law status, Rebel Teacher. Make sure you click on my member tab and take the link to Discord. Let Jung know who you are in Discord, so you get access to the entire thing. Please note, hallucination in Ethan's age is very uncommon unless he has substance use involved. And it might have been. Remember, in the text message, the father said it looks like he got really drunk last night. It was way too much to drink. So maybe he did get into something. And
But
that's why he's
also-
being punished.
hallucinations. Like if he's saying he's seeing ghosts, like that's all somebody else's perception. You know what I'm saying? Like
Yeah.
people out there see ghosts. Like
Mhm.
it's not necessarily, you know what I mean? I'm not
And
trying to be, like,
maybe
super weird,
maybe
but
Jennifer is going to testify and say, yeah, we had a problem with him using drugs, and we were
Yeah.
quietly trying to combat that. We didn't want to go to the police. We didn't want to make this a big public thing.
yeah.
Who knows what she's going to testify to? But my point is right now with this text message, Ethan is a witness against his mother, and she is unable to cross-examine him. And I feel like this is depriving her of her fundamental rights to confront the witnesses against her.
100%.
Laughed when I told him.
That's correct.
Okay. Now, April the 5th at 12:06 a.m. So we were looking at a conversation up.
Jennifer
right up until
is going to
midnight on April
testify.
5th, Now we're in the early morning hours. of
Jennifer
April
is going to
5th.
testify.
What did the shooter write?
Shooter wrote, but I'm having bad insomnia RN for right now and paranoia.
And then what?
He then says, I need help.
Okay. And the next line, or the next. Text?
I was thinking I calling 911 so I could go to the hospital.
Then there's a response from his friend on April the 5th
Correct.
at 12 a.m. And then what did the shooter write?
The shooter writes, but then my parents would be really pissed.
I agree, Joan. It's very attention seeking sometimes.
Now, April the 5th, 2021 at 12:38 a.m. What did the shooter write?
Shooter writes, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. Then he says, but this time I'm going to tell them about the voices.
Okay. Next text.
He then says, like I am mentally and physically dying.
Before we get to Exhibit 102, in the course of your forensic examination of James's phone, Jennifer's phone, and the school shooter's phone, you're able to look at certain apps that are installed. Is that right?
That's correct.
Okay. And did you discover if an app called Life 360 was installed on Jennifer Crumbley's phone?
Yes, it was.
And what is Life 360?
Life 360, it's a
I have
it's a tracking
Life
app that friends and family can install on their phone so
You
they
have
can
that
know where they're at.
Mhm.
I have it on my phone, and there's a family group that my kids are on it, and I'm on it, my wife.
That way my mom knows where I'm at.
Did you find that app on James Crumbley's phone?
Yes, it was.
And through that app, you can see where someone's at and where they've been. Is that right?
That's correct.
And you look through the school shooter's phone as well, the defendant's son.
Correct.
Was that app installed on his phone?
No, it wasn't.
So it was just installed on James's phone and Jennifer's phone.
Correct, it was.
And that was on April the 5th of 2021.
I believe that's when it was installed, yes.
Okay. That's the same day as these text messages, like I'm mentally and physically dying and asking to go to the doctor.
Correct.
Exhibits 102 and 103.
I'm sorry, are these, this is 102 and 103? We have no objection, sorry.
102 and 103. I'm sorry, did you say that the date of installation was April 5th? Is that what you said?
Yes, ma'am.
So on the screen here, we can see the timestamp purchase date, April 5th, 2021.
I'm trying to get my stream set up.
Correct?
Correct, yes.
Okay. And exhibit 103 on James Crumbley's phone, we have April the 5th, 2021 as well.
Correct.
What are they whispering to each other? I can hear them.
During the course of your evaluation of all the electronic information, digital evidence available to you, did you uncover evidence in the spring of 21 of Jennifer Crumbley talking to a friend about what she saw as depression in her son?
Yes.
And were you able to review a Facebook conversation between Jennifer Crumbley and actually the school shooter's only friend's mother?
Yes.
Okay. So I want to make sure that I'm clear with you.
Wait, what?
April of 2021, which is
Oh, only friends. I heard only fans. Okay. The shooter's friend's mother. Got it. But the way he said it, I heard OnlyFans. Sorry. I got all like, it's the first time I've heard about an OnlyFans account in this case.
same month of these text messages. Jennifer Crumbley texted her son's only friend's mother, correct?
Good
Okay.
morning.
And in that
does sound
conversation
like
is when
that.
you uncovered
Doesn't it sound like that?
concerning text messages as an investigator to this case.
Correct.
This is 104.
Thank you, and let me just take a quick look, I'm sorry. Yeah, I have no objection to this, thank you.
104 is on there. That's just one.
All right.
Yes,
I am
thank you,
pinning in the chat a
Okay,
link
this is April
to
29,
right back off if you guys want
2021.
to join over there later
Now, this
when that
is
gets
from
going and we shut this down.
Jennifer Crumbley's search warrant return, correct?
That's correct.
So she's agreeing to these.
Correct.
All right. So what does she write?
She starts with, Ethan isn't bowling tonight. Just want to let you know. Not sure if they need a partner or not.
Okay. And then her son's friend's mother, also named Jennifer, writes, is he feeling okay?
Correct.
And the defendant's response?
She responds back with, yesterday he wasn't, and he's been acting kind of depressed. So I don't know what's going on.
Okay. Does this conversation continue?
Yes, it does.
What does the defendant write?
The defendant says, I'm not sure if there's something bothering at school. He really doesn't feel good. I can't get anything out of him.
Okay. And the person she's communicating with writes her son's name too. He stayed home from school today. The only time he's happy is when he's with school shooter.
Correct.
Well,
And
he's
then
with his
Her
parents
son has two
and
Bs
there's
two Ds. I'm wondering
they're
if he's
there
worried
with
about
him.
that.
So I don't
That's
see the problem.
the other individual worried about her own son.
Correct.
Okay. That's 5:24 p.m. on April the 29th.
Yeah.
That's correct.
The conversation continues. What does the defendant write?
The defendant says, yeah, this is all new to me. I'm not used to Ethan being moody. He's usually pretty happy, and we'll talk about anything. I do know Ethan's been stressed about school and his grades. We called the school, but she wasn't in. Social, do it tomorrow. I think his grades have a lot to do with it. He just got to a point where he got so far behind, we were out of town. He's having a difficult time making it up.
And then the other individual writes, I'm sorry, her son's struggling too. To be honest, I'm sick of fighting with him about it. Stupid online school really messed him up. I'm thankful her son has the shooter as a friend.
Yeah, and that's
They
the other
laugh and
thing
have a
too.
great time
What
together.
kid
It's April 29th, 5:31.
that took a year
That's
off
correct.
school during the vid and then going into high school immediately didn't have problems? Schools were struggling with it everywhere. It wasn't just
And then
Ethan,
what does Jennifer respond?
you know, he
Jennifer
wasn't
responds
special
with,
in
yeah,
that
me
regard.
too. I'm just glad they're still getting along. And it wasn't an issue with those two as to why he was being depressed. The online school is horrible. I've given up too. I just told him to do the best. Don't worry about it. Next year is a new year.
Okay, and then what's the next text?
She says, maybe if, is referring to the shooter's friend, feeling better, if he wants to come over after work on Saturday, he can take him up to go bowling and make up their scores. He's more than welcome to stay the night and go to work in the morning. We set up a little shooting range in the backyard for Ethan's BB gun. They could do that.
Okay, and the response was her son's been excited to shoot.
Correct.
Okay, and that was April 29, 2021?
Yes.
Is
Okay. Now-
any of this information?
Around this time frame,
I'm going
text
to
message,
end the poll. I'm going to put the poll up I had
videos on the
before.
school shooter's phone, did you discover extremely disturbing information?
Yes, sir.
Okay. And
They'll
I'm
never.
not asking you to go into detail, but as an investigator, it was important to you.
Yes, it was.
Okay. And in fact, it was in the days after these messages were sent.
Yes, it was.
And
Are the text
the school
messages
shooter
making the
shared
defendant
that
look
with
more guilty?
his
Yes or
friend,
no?
his only
That's
friend
the
he had.
poll that says.
That's correct.
I think they're prejudicial.
You mentioned that his only friend was taken out.
Wicked Psych with a 3-month member chat. Thank you very much for being a member for 3 months. Can the defense use Ethan's statements from hearing? Well, one would hope that they'd be able to. Actually, what the defense is fighting to get in, and what the state has been fighting to keep out, is his medical records. So it sounds like they're going to get those in. That's the biggest thing. He doesn't have any psychological issues after all these assessments and things like that. That's the biggest thing that they're going to try to use against him. Presumably, if he was going to be called to the stand, then he would absolutely be questioned about that, those statements. But they're not going to be able to like play it in court or anything. Maybe they could get a transcript and have somebody read it in, but I don't know. Well, with this judge, maybe we can get it under present sense impression, right? I guess potentially. I wonder if the pregnant Karen has other kids. Let's see. I wonder if the pregnant Karen has other kids. The defense counsel, is she pregnant? I know you guys keep talking about that, but I don't know if
It
we've
looks like
confirmed.
I mean, the side view, but it looked like it was just a little tiny belly.
Yeah. I don't
But I
think
don't know.
the prosecutor Karen is pregnant.
Not
Of the
Karen.
state,
Correct.
and it seemed to be without notice
The
to
Karen
school shooter.
Karen.
Correct.
Yeah.
Did you uncover evidence that either James or Jennifer Crumbley commented on the fact that his only son was taken, or his only friend was taken out of the state?
Yes.
I think they filed a motion regarding this this contradictory positions that the state is taking. I don't know what the judge issued as far as limiting their arguments regarding that. I don't know. Honestly, I just don't know. I'll have to look into that.
Yes, I have no objection to 105, thank you.
105 is in there?
And you
What?
said that was
Sorry, just for anyone who doesn't know, what John Gary is getting at is that the state made the argument in Ethan Crumbley's Miller hearing and Ethan Crumbley's sentencing that it was all Ethan Crumbley. Essentially, that his parents didn't neglect him, or he has to take responsibility for his own actions. Was the position of the exact same two prosecutors in Ethan's case, and now they're saying, "Oh, but we got to hold mom responsible." So that seems like two contradictory positions, because they are. And the question was whether or not the state would be allowed to use it. My position has always been is you can't use the prosecutor's arguments in a different case because one doesn't affect the other. They're essentially irrelevant. So in theory, the state can argue two contradictory things in two different cases, and both are lawful. I don't know of a justification to get around that, at least in Michigan.
around about a month before the shooting in Oxford High School?
Yes, it was.
Okay. So this is from Jennifer Crumbley's Facebook, again, to the mother of her son's only friend.
Correct.
Okay, and this is October 31st, 2021, 9 o'clock in the morning?
Yes.
Okay, and what does she write?
Jennifer writes, James filled me in on Ethan's friends last night. I'm so sorry you guys are having to make such a hard decision. Please let me know if you need anything.
Okay, and then November the 3rd, she wrote what?
She says, how are you guys all doing? Been thinking of all of you a lot.
Okay. And you know from your investigation, this is the time frame when the shooter's friend was taken out of state.
That is correct.
Okay. In this conversation, November the 4th, that other individual writes what to Jennifer Crumbley?
She writes, hi, Jen. We're doing okay. It was the hardest thing I've ever had to do. I worry about him constantly and miss him terribly. I know that he's where he needs to be to get better, though. Thanks so much for checking on us. I appreciate you and your family. She's referring to her son.
So her friend
is only happy and relaxed with you guys.
Ethan's friend's mother made the appropriate choice.
Jennifer responds
Jen
with,
didn't,
please
so
keep
therefore
us updated. I know Ethan misses him. If you guys need anything at all, please don't hesitate to ask.
And that was, again, in November of 2021 before the shooting.
Correct, on the 4th, yes.
Okay.
Jung, can you confirm this? I
No,
believe this
I'm going
to be true as well, but I want to hear it from Jung.
Direct your attention to the days around the shooting and what you were able to obtain as far as a digital footprint of the Crumbley family.
Okay.
Starting November 26, 2021, is that date significant to you?
Yes, it is.
Why is that?
That was the day the gun was purchased.
And we heard yesterday that the gun is in the murder weapon?
Yes, sir.
Okay. That was a 9mm Sig Sauer handgun?
Yes, it was.
Okay. That's been admitted in evidence, and we heard it was bought from a firearms store in Oxford.
That's correct.
Okay.
Jung, you're driving. So the question, it wasn't really a question. It was a statement that mental health professionals do not like to diagnose teenagers with mental health illnesses. And I was asking you to confirm that. Please text while driving some more. So the poll that's up is are these text messages making the defendant look more guilty? 15% of you, 16% of you are saying yes so far. 84, 85% are saying no. Jamie, what are your thoughts?
Okay. This is just as an example, what information you could.
I think, in the jury's perspective, yeah, I do think that bringing this kind of stuff up looks bad on her. I think it's very prejudicial, but that's just my opinion.
I
I
think
feel.
it basically makes the defense have to testify. And
Yeah.
that's why I don't like this, because she can't confront her witness against her. She has to now take the stand. And it's almost kind of like burden shifting, right? I don't know. I'm feeling all icky about this.
I know, that's what I mean. Like, it just feels really icky because it's like
Yeah.
they're bringing up all these things that he was doing that they didn't necessarily aware of. And I don't like it. I don't like when they're bringing in videos and talking about everything Ethan did and this at the school and the shooting. And it's like so icky to me.
Yeah. And obviously, we have no way of knowing what the jury is actually thinking or going to think.
Yeah.
So we can't guess what they're going to say. But if I was sitting, I'm trying to put my mind in the position of the jury. And that's why I like having Jamie and Danielle on, because they're not attorneys. They're not thinking of this and from a legal standpoint. Danielle, what are you thinking? Are these text messages making her look bad, more guilty?
I don't think so.
No.
I mean, maybe to the jury, like Jamie said, but
Yeah, like my opinion.
I don't think it makes it look guilty. Like, no.
Yeah.
Okay.
That's what I mean,
I'm hoping the jury is thinking like you two ladies.
Hopefully. Well, we hang out with a cool
From
dude,
search
so.
warrant on a Gmail account.
That's correct.
Okay. And so this is from James Crumbley's Gmail account, November 26, 2021, confirming that he was in fact at that firearm store at 12:08.
Young Min says mental health professionals do not like to diagnose teenagers or young kids with severe mental health conditions
No.
because those things can always
talked
change
about,
because of
obtaining
brain
locations from
because
somebody.
of brain
This
changes
is,
happen.
107.
That makes
Right.
sense.
We have no objection.
That's the reason why they argued in the Miller hearing that
Before
he should
we,
not be
get
sentenced to
into
life without the
107,
possibility of parole.
Exhibit
The very
417,
same
it's a
thing.
video. Sir, in your analysis of the shooter's phone and Jennifer Crumbley's phone, social media accounts, you were able to obtain videos taken by the school shooter with that handgun, the murder weapon?
That's correct.
Okay. So 417, people moved to admit and publish to the jury. It's a video taken from November 26, 2021.
And Your Honor, I'm sorry, I have to just take a look really quick. Because we just jumped ahead like a couple.
Yeah, it's 417.
Yeah, let me just take a quick look. I'm sorry.
Exhibit 417.
And
And
David,
actually, I don't
Yeah.
have 417.
Jung's follow-up.
In the exhibits that I was given, can I see?
Also, on occasion, someone gets a diagnosis like bipolar because insurance requires it
Wasn't
to
on
be
my hard drive, but it was given.
requires it to prescribe a medication, but maybe all the
Your Honor,
criteria
I
is
have no
not met.
way to play this.
and
I
I'll
don't-
jump on
I
that.
don't
It's
have
very
this.
common to receive medications that are off label because they're just finding a diagnosis for it, unfortunately. So it's very common.
Yeah, I know I work with a lot of mental health professionals and they're always reluctant to diagnose, period. But they will say things like that somewhere in the file, usually because it is like a prescription or somebody wants a report. Like courts all the time are like, can you diagnose this person? Give us a diagnosis. And they're so reluctant to do it. But they're like, well, it's consistent with this. There's signs of this. They're dancing around the idea because they don't want to diagnose someone.
All these
Can I
exhibits
just
are-
have,
it's a very short video.
it's not on our, I just need to see what the video is. Can we just unplug the computer and can you just show it to me really quick?
Is there audio?
This is bad communication between prosecutor and
We're showing a
defense.
preliminary examination as well.
Your Honor, I'm
This is
sorry,
what
it's not
I
on the
always
exhibits they
do.
gave me on the desk, so there's a million videos in this
Is
case.
if I
and don't know
have exhibits, like I'll have stacks and stacks of exhibits that I might introduce, but once I get a final cut of all my exhibits, I give them to the other side. I make 3 copies immediately, maybe 4, depending. And that would be one for the witness, one for me, one for the defense, one for the judge. And then I have them just to hand out.
And I apologize, I
No, it's okay. There's a lot of stuff. I don't want to read the jury because their lunch is not made. I haven't made your lunch.
Oh, yeah, sorry.
The judge hasn't made their motion.
I'm having lobster.
I'm speeding it up a touch.
Okay, and so this is 417.
417.
Okay.
And just a reminder, people, after this stream is done, which will be ending, I think they're going to go to lunch in about a half hour. So I will send you guys over to my next stream so you can click the notification for this afternoon. When they
Okay, we have
come
no
back
touch
from
on this
lunch,
one.
we'll go
And I
live.
apologize.
That's right. Just have it.
Thank you.
And
There's a lot of stuff. Okay, so 417 is.
there is a link to the laid back law stream that I'll be appearing on if you so desire to watch me on that.
Okay. Yeah, Jeff?
Sure.
Thank you.
That's
This is
pinned
what you obtained from
on the other stream.
shooter's phone, and it was captured 6:39 p.m. on November the 26th, 2021.
That's correct.
So that video was taken the evening the firearm was purchased,
Correct.
and that is in fact the murder weapon, the 6 hour.
Let's see if there's
Yes, sir.
Google locations showing that James and Jennifer were home at the time. Or not home at the time.
I have no objection to those.
107 and 108, Judge.
107 was previously admitted, 108 is admitted.
Okay, now, Agent Brandon testified yesterday to much about the evidence regarding the firearm, so I'm going to move you ahead to November 27th, which is the next day, the day after the 6 hour was purchased.
Okay.
All right. So,
Hey, where's the Google data? The location data.
all right, 107.
Is this it?
This is evidence
Okay.
obtained from James Crumbley's Gmail account. Is that right?
That's correct.
Okay, so you were able to tell what James Crumbley was doing from 8 a.m. to 8:59 p.m. on November 27th, 2021.
Correct.
Okay, and tell us what was he doing?
He was delivering DoorDash.
So these dots, these data points are what? What are they signifying?
Those are the GPS locations that were provided when the location services was turned on from Google.
So we know he was out of the house basically the whole day.
Correct.
Okay. Now, 108, we have Jennifer Crumbley's Gmail data points. And from what time period?
That's from 2:29 p.m. to 3:32 p.m.
Okay, and this is exhibit 108. It shows she's out of the house from about 2:30 to 3:30. Is that right?
That's correct.
Okay, thank you. Now,
What time
the
was
next
that
day is
video made?
Sunday, November the 28th, 2021.
Does anyone recall what time that video was made? I don't want to go back.
Could you get a feel for what
So
Jennifer Crumbley was discussing based upon her Facebook messages, what her
That's
plan was doing on November
a weird
28th,
question.
2020?
November
In
26th,
fact, you
6:39 p.m.
Chat
Is that what you're
So
talking about?
November 26th, 6:39 p.m.
6:39 p.m. Defendant video by defendant's son. Is that what you're talking about? That
Yeah.
slide.
Okay, so 6:39 p.m. So the Google location of James is like 8 to 9. So that's outside of when the video was made. And then Jen's is in the afternoon. Okay. That's outside when the video was made.
history with an individual named Kira Pennick.
That's correct.
Okay. And through the course of this investigation, did you come to learn who that person was?
Yes, I did.
Who was that?
She was the owner of the horse farm.
Okay. That's
How
the
does
horse
that make
farm
sense
where
then?
Jennifer and James Crumbley would board their horses.
Correct.
Okay. So she's going to testify later on in this trial, but you reviewed
No
their
spoilers.
Facebook chat history.
Correct.
So that's 109. People move to 109.
Your Honor, can I just have one moment? This is a,
It says it's a thread between your client and Kirk Pennick on November 28th. That's what it reports to me.
okay, and the exhibit that I received from the prosecution is 967 pages long. So I'm thinking that what I got is not, is not.
See, this is on the prosecutor.
We're not gonna go through 1,000 pages.
No,
No, I-
give her
I
the
just-
pages ahead of time
Okay, I'm
that you
sorry, so
intend to
what
show.
pages are they admitting is?
9:30 to 9:33.
Okay, 9:30.
He doesn't have to be snarky about it.
Sorry,
Yeah. No.
I got the whole file, like,
It's on the exhibit list. with
Yeah,
the
there's,
pages.
the exhibit list indicates, this exhibit list is what I got on Tuesday. I'm not sure when it was shared with the defense, if it was the same day or not, but it says pages 930 to 933 are the only ones they're seeking to highlight.
I know, I'm just scrolling.
Okay,
It's,
go
it's
ahead.
just taking me a little bit to scroll through.
I'm not becoming a fan of this defense attorney. Get a mouse with the wheel.
I need to use my computer.
I don't know.
I'm sorry, I'm trying to get to 900. It just takes a little bit to load.
Use Control F and do key search terms. She's rubbing me the wrong way. I want to root for
Okay, so
her,
it's pages 901.
and I'm still on her side, but I'm just not liking her.
Exactly what was written on the exhibit list.
And
The prosecutor's like, exactly what we wrote. See, I didn't know there was an exhibit list until just now. And the judge was like, yeah, it clearly says these are the pages we're using on the exhibit list.
On every other
Okay.
exhibit, they have
Oh,
narrowed it
well,
down.
then you have no
It's
excuse,
much
lady.
bigger. I just need
I'm
more
done.
room.
I'm done with her.
It says, the pages. that they're-
I
I'd
know,
like
I
to
can't
see
pull
the
up
body
the
language
slides. My
analysis
computer's-
on
I'm
these
trying to
lawyers.
as fast as I can.
That's what we need. We need Dr. G
Okay,
in
I
here
have
to
no
give us some
objection to
body
this.
language.
And we
Oh,
don't need
good.
you
We
to.
finally got there.
Yeah, let's go.
Thank you. And this is a portion of.
Yeah, she's bugging me. I want to like her because I like her position, her legal
Okay,
position.
So
I'm
green
just
is who?
It's Jennifer.
Okay, and what's she writing?
Was his front swollen again?
Okay, and then the response?
Is from Kira Pennick, right? I'm the same. I'm not sure. I'm not doing chores, but I'll ask my dad when I see him.
Okay, so did you come to learn when Jennifer writes, was his foot swollen again? She's referring to one of her horses.
Correct, yes.
referring to a horse.
And
Mind you,
Kira's-
every day I have to go out now and I have to scrub my horse's foot, and then I have to put this medicine on it because he's got the same thing. And you got to do it at least every day. It's a thing that has to be done. And if I can't get to it, the wife's got to get to it. Someone else got to get to it.
response?
If Billy keeps stocking up, I think you should have the vet out for him. Just want to make sure it isn't anything serious.
And Billy's who?
The horse.
And Jennifer's response?
Like the
He's got
position not to play
mid-fever.
it. Yeah,
James is
exactly.
coming out in the
KPM.
morning to put some stuff on him and calling vet for antibiotics. And then she corrects with mud.
Billy's one horse and they have two horses at this point, right?
Correct.
And then what does Kira say?
Kira,
Yeah, I literally
that's
just
crazy.
yelled at
You've
my
never
kids. I
seen it
said, "Don't
react like
bother me
that.
from
Want me to
8:30
just put stuff on it daily?
Monday
I
through
can.
Friday
I
morning."
didn't do chores this weekend, so don't know if it got done.
So the last message in this exhibit from Jennifer Crumbley to the individual who boards those two horses is November 28th, 2021. That's Sunday, 8:18 p.m., Sunday night.
Correct.
And she writes, yes, let's do Tuesday. I'll have James leave the mixture out there. I don't think he's sore from the ground. He's just fine lunging. Just need to keep moisture off his scratches and get him on antibiotics. Should be clear in a week.
That's correct.
And that's again in reference to one of our horses.
That's correct.
Okay.
Yeah, I'm not liking the green color.
Did Jennifer go to the barn that day?
It hurts my eyes.
Yeah, me too.
I have an iPhone, and when I
Yes,
text
thank you,
people that don't have iPhones or are not using iMessenger and it turns up
Oh.
green, I hate it.
It's
Yeah.
appalling.
110. This is from her Gmail search warrant return. We can tell that she's at the barn at noon on November 28th.
That's correct.
Okay, and she's back at home. This is exhibit 111 at about 2 o'clock.
Can you borrow the defense woman, your paralegal? You're not working? Yeah.
Now moving on to Monday, November the 29th. That's the day before the shooting, right?
That's correct.
Okay. Now, what's the first
Danny
thing
T, that's a fair question, right?
that you
But
see?
I'm not here to judge their
reports
finance.
to you as a forensic
financial
investigator from the
decisions.
day before the shooting that occurred on one of her devices.
It's a fair
It was
question,
a
but
web history search or a web search.
people have their hobbies.
This is exhibit 113.
Yeah, and they're not top quality horses. They're not. These aren't thousands of dollars.
No,
For these
112
horses.
was not omitted. That's
Yeah, 112 is not admitted.
Correct.
Okay, so 113, we have no objection. Thank you.
113 is in there.
Thank you. Okay.
I have
113,
questions for anyone who doesn't have an iPhone.
This is a snippet
Danielle,
of the
do you have an
celebrate
iPhone?
extraction report
I do.
of Jennifer Crumbley's web history.
That's correct.
Okay. So tell us, please, what was she researching November 29th, 2021 at 3:05 in the morning?
In the second column, you can see where it says research clinical depression treatment options. It was Yahoo search that was used.
Okay.
In the third column, you can see exactly that's what was in the URL.
What was that, Jamie?
Sorry, I thought I was muted. I put my plate in the sink.
All right. I wanted to stop this because she is researching Jennifer Crumbley's web history. She is researching clinical depression treatment options. Do you guys see the date? It's November 29th of 2021. She's taking an active step in researching this the day before the pew pew. This is the day before. So she's not neglecting the child. It's kind of my point.
Press bar that you type
And that's the day before the shooting in the early morning hours?
at 3:05 a.m.
Ex-comer with the 20 North Korea dollar dues. Any drug report on arrest? I don't believe so. I have not heard anything about any drugs at all. The only thing I heard about is mom likes to get drunk and ride horses. But I appreciate the 20. Is it 20? Yeah, 20 North Korean dollar dues. Thank you very much.
All right, now let's talk about the Facebook conversation between James and Jennifer from later that day, Monday the 29th. This is 114.
I have no objection.
114 is in there.
Does the fact that she's searching it on November 29th, the day before the pew pewing,
November the 29th,
make her more or less guilty?
2021, 8 a.m. Jennifer writes to James, "Are you at the barn?" And then about 40 minutes later, she sends a question mark. Is that right?
That's correct.
Okay. And then James responds to what?
He responds with starting with the question mark, working on Billy.
Okay. So it appears, at least from this message thread, that he's at the barn with their horse Billy.
That's correct.
No, Billy is one of the horses.
And then he sent a picture.
That's correct.
Can you tell what that's of?
It's the horse's legs, it appears.
And what does Jennifer respond to that picture?
Do the fronts too.
Right? That's what I'm saying.
Okay, this is
Ziggy.
9/21.
Can you imagine having your complex life being drugged under a microscope and then having to explain all of your actions and decisions on a world stage, but also, I hit my mic, also the seemingly innocent things that you do, such as a random text message to your son or from your son, or going to the horses and all of this random stuff that is completely innocent. Now you have to explain it. Oh, I turned my phone off. Yeah, because I was having that kind of day. And I just felt like, you know what? I'm turning my phone off. Well, now you turned your phone off. You're unaliving somebody or you're being unalived or whatever. You know, It's just all these seemingly random things that get drug out. Your entire complex life is getting focused into these slivers of evidence. I'm going to use it. Slivers of evidence for the forest of the trees.
And everyone and their mama gets to armchair parent and tell you like how you should have been parenting.
Well, including us.
Well, yeah, but it just makes me laugh because it's like, then people want to tell you, well, I would have done this. Why didn't you do this? Well,
that's why I put my life on YouTube. I can't say I wasn't here saying things, and you can watch the whole context. I don't know. It's a problem with a lot of these prosecutions that we see, and it's a big problem with this one. How did we ever determine when somebody died before cell phones, right, Farrell? That's a good question.
You didn't answer your landline, were you dead? I don't know. Like, were landlines a big deal back in the days?
I don't know. Were they?
I don't know.
And what does Jennifer say?
Jennifer asked, did you call the vet?
And then what?
Make sure you get back in between his heel balls.
Okay. And James's response
Yes.
to
He responds
Mass.
with, I did.
People love
and
telling
then
you how to
fronts
parent.
two.
And that's at 9:34 a.m. on November the 29th.
That's correct.
At 9:35, what does James say?
He texts, what exactly should I tell vet? Type out for me, leaving barn now.
Okay. And then Jennifer responds, Billy looks to have scratches / mud fever. He's starting to stock up on all fours and concerned about infection. He's not lame, sensitive to the touch. And
It's
they
a
go
good
down
question,
when he moves.
Megs.
Is there an antibiotic? I can get him on?
Mangs.
We
I don't
just
know.
put Guessington
Did you
and
pronounce
put
the
that
N?
material on his legs today.
Mangs.
November 29th, 9:41 a.m. Is that right?
That's correct.
Okay. And then she sends a message to him.
Correct.
And what does she say?
She says, was he stocked up this morning?
And then James's response.
James responds with, he was stocked up more in the back than in the front. In fact, the front didn't really look stocked up at all. So I launched them for a few minutes before, put the
Plunge.
stuff on it.
Did you
And it
misspell
took the
it?
swelling down
Plunge.
a
What
little
is-
bit, but I got the
Are they
cream
talking
all
about
over,
horse
in between the
stuff?
heel bulbs.
Yeah, okay. So he dug out the shoes, right? He cleaned the crap out of the bottom of the horse's hooves, and then the legs get swollen up because it's a bacterial infection, and so you have to have the horses move, but you don't want to put them in the mud, so you usually have them in the stalls, and then you got to work them. So he's lunging them, having them run in circles, so that the swelling goes down to the legs, and then he puts the cream on and puts them back in.
Well,
That's what
why are we
I don't know
extensively
why we're talking
horse
about
stuff
this.
right now?
I don't know, but because they're so concerned with their horses, they're going into great detail about their
Yeah.
horse, but you don't have these same text messages about their son. Why not? It's because they care more about their horses than their
God.
son.
Like I get
Jimmy.
where they're going, but it's annoying me.
They care more about their horses than their son.
Okay.
And stuff like that. I'll call the vet here in a minute.
Now, sir, it's been a little tedious going through all of the messages regarding the horses. Give us an idea.
Yeah.
Because you're the one who actually extracted the
You said it.
information from Facebook.
You said it.
How often will they show concern over their horses?
Quite often.
See, this is exactly what I said they were going
Good. Yep.
Okay. In Jennifer's response, this is the same conversation, November 29th at 9:58 a.m.
She responds with, it made sense, LOL.
Okay. And then James responds more about the horse. Is that right?
That's correct.
Okay. And Jennifer responds to that message,
Yes, she did.
and that's at 10:15 a.m.
Correct.
Okay, so Fedorowski makes a fair point, right? The horse has a bacterial infection, and they're talking about treating it and what they're doing. When the son had an incident or an issue or whatever it was, they're back and forth. How was he? Oh, he looks like he had way too much to drink. Okay, did you give him anything? Yeah, I gave him a pill. Okay, I'm also making sure he's cleaning up and doing his homework. Oh, okay. They're talking at great length about their son when there's an immediate issue, just like the horse.
But also, we don't know if they had these conversations in person.
I know.
Maybe they didn't talk- I know.
their evidence and how I would argue
No.
this.
I'm not yelling at you. I'm just saying, like, there's so many things they probably had in person that we have no idea about.
Yeah, no, I know exactly where this prosecution is going, and it's sickening because they're going to use all this stuff, but they're not seeing the freaking forest for the trees or whatever you want to call it. But you can make the same exact argument, and I hope the defense is picking up on this, that when they're talking about, oh, they're really focused on the horse has an illness, and they're focusing on it. But when their son had an issue, they're focusing on that. Look at all these text messages.
Now, this same day, same time period, did you uncover evidence that someone from Oxford High School left a message for Jennifer Crumbley?
Yes, correct.
Okay. And in fact, that was at 9:41
Apparently, Aaron.
a.m.
That's correct.
Okay, so that was in the midst of the Facebook conversation between James and Jennifer about their horse.
Correct.
Okay. And we
I don't
were
know
able
if
to
any of this
obtain
is
that
true, but I
voicemail
find this
from
funny.
Jennifer Crumbley's phone records.
Yes.
I can't confirm or deny this because I haven't heard the evidence about in this trial. I haven't heard the evidence, but keep in mind that at this time Jennifer covered herself, but not Ethan, on her company health plan while she was spending all of her money on vet care after buying a horse for $5,000 while drunk.
My mom bought a horse for no reason and kept it for like a month.
Yeah, people do
It's
things.
not uncommon.
But honestly, I don't know if any of that's true. I just thought it was funny.
People moved to him at 1:15.
No objection, Your Honor.
115 is admitted.
Thank you.
My name's Pam Vine. I'm calling from Oxford High School, and I'm here with.
Okay. All right. This is important, people. This is the voicemail left on November 29th. This is the day before the shooting. This is how concerned the school is. This is the school. I'm going to turn this way up. I'm going to step it back. Listen to this. If you haven't heard this before, they played this at the preliminary examination. This is how concerned the school was over Ethan looking up bullets on his phone the day before the shooting. And this is also why the counselor who's going to testify and say, wow, we thought he was safe to go back to school, knew that Ethan had a gun or had purchased a gun recently, not like with him in the school.
115 is admitted.
Thank you.
My name's Pam Vine. I'm calling from Oxford High School, and I'm here with Ms. Hopkins, who's Ethan's counselor. I was just calling to let you know that we just spoke with Ethan, had a really nice conversation. One of the teachers had sent an email to the office. She was concerned because Ethan, when she was walking around the room, checking his silence, but he was on his phone looking at bullets and that sort of thing. So she just wanted to have a conversation. We did. So he said the shooting range with you this weekend, and we're like, yeah, guns are a hobby for a lot of people, and shooting ranges, and that's perfectly normal. And that we just wanted to make sure, had a conversation with him about the things he searches at school, and things versus searching at home, like Mr. Hopkins gave a good example of like if a teacher makes beer at home, perfectly normal and healthy, but can't be using searches for making beer at school. So we had a conversation. He was great. He said, yes, I get it. So I just wanted to let you know we did have a conversation with him, and about 5 minutes, and he was back to class. All right, if you have any questions, you can give me a call. Otherwise, it'll be a great holiday. Thanks. Bye-bye.
Okay, that was the day before the shooting at 9:41 a.m.
Correct.
Okay. Did Jennifer Crumbley access that voicemail?
Eventually, yes.
Okay, this is exhibit 116.
I have a better clip of that
No
voicemail.
objection.
I'm going to put it in Discord
Thank you, Joe.
so you guys can listen to it again.
And according to your analysis, she accessed the voicemail at 11:49 a.m.
That's correct.
Okay, so that's still in the midst of the conversation she was having with James about their horse.
Correct.
Did you uncover evidence that Jennifer Crumbley texted her son about that voicemail?
Yes.
Okay. This is exhibit 117.
I have no objection.
117 is admitted.
Okay. Now, owner Green, this is
Yeah, I mean, so the summary of it is essentially, hey, we just had a conversation with Ethan. We brought him down because one of the teachers notices he was looking at bullets on his phone. We had a conversation with him and the other assistant principal, and the other assistant principal explained to him, like, hey, listen, I like to brew beer at home, but I can't look that stuff up at school. We understand that he just got a new gun and he's been going to the firing range. That's cool. That's completely normal. And we just can't have him looking that up on school. He was understanding. We sent him back to class. Just wanted to let you know. No big deal. Call me back if you have any questions. Otherwise, have a great holiday. That's essentially what the school just said in a very friendly and non-emergency, non-concerned way.
Jennifer, because it's from her phone. Is that right?
Correct.
Okay, and in fact, you were able to take the whole text message conversation that existed between James and, I'm sorry.
Yeah,
between
Rachel, that's a completely
Jennifer Crumbley
different
and her son.
question.
Is that right? And if it were to be printed out, it'd be over 200 pages or so. Is that right?
Sounds about right, yes.
Okay. So I'm going to show you portions from November 29th, and we'll refer back to this. So November 29th at 11:53 a.m., this is a few minutes after she listened to the voicemail. What did she write to her son?
She says, seriously, 2 question marks, looking at bullets in school, question mark, question mark.
And he writes back, what? And then, oh, yeah?
Correct.
And then he wrote what?
I already went to the office for that. It was in first hour. All I did was look up a certain caliber at the end of class because I was curious. It was on my phone.
Okay, that's 11:53 a.m., November 29th.
11:54.
11:54.
Yes, sir.
And then what did he write?
Completely harmless. Teachers just have no privacy. They said I'm all good.
Sounds like a typical teenager.
And then the next message.
Stupid teacher's looking at my
The
phone.
shooter continues, I understood why. They talked to me and they said, I'm good.
Okay, and then he wrote, this is nothing I should get in trouble. This is nothing I should get in trouble about.
Correct.
He wrote that to the defendant at 11:55 a.m.
That's correct.
And what was her response to that?
You're not. They left me a voicemail with the hand over face emoji twice.
Okay. And then what did she say?
She then says, did you at least show them a pic of your new gun?
So she wrote at 12:14 p.m.
See, I feel like
"Did you
that
at
was a
least show them
joke.
a pic of your new gun?"
Correct.
And his response?
No, I didn't show them the pic. My God.
And then what?
Oh my God.
I only told them I went to the range with you on Saturday.
Okay. It was, I only told them I went to the range with you on Saturday.
Correct.
Okay. And then what did he say?
It was a harmless act.
Go ahead.
I have this bullet cartridge in my room that I didn't what kind of bullet it was, and it said it was a 22. So at the
He
end of the
reads
first
like I
hour,
do. I
just
am
looked up
redeemed.
different types of 22 bullets. And I guess the teachers can't get their eyes off my screen, SMH.
And then what did Jennifer respond to that?
She responds with, LOL, I'm period, not mad. You're not, you have to learn, not period, to period, get caught, period.
Yeah, see, there should be a sarcastic emoji that you could just put at the end of everything so people read it with a sarcastic inflection.
But did you hear him say,
His response to that?
my gun, my gun? He like accentuated
The
that
way
when
he said
read
it, the way he read it.
Yeah.
All right,
He
let's see.
said, my gun. Did anyone catch that?
Learn, not period, to period, get caught.
Oh,
period.
I don't want to back it up all the way.
Yeah, you're
Okay, I know, LOL.
And then?
2 laughing emojis. And then he responds with, I just didn't want something this little to get me in trouble because, well, I didn't want to get in trouble, LOL.
Okay. And then what did he write?
The shooter says, I want to hear the
Flash
voicemail
S
when I get
stands for
home, though.
sarcasm.
Also, I never tried to hide me looking up the bullet. I just didn't think a teacher would be staring at my phone.
And then what did she say?
Teachers, no privacy.
She says, okay, I saved it.
Sir, did you find evidence that Jennifer discussed this incident with her husband, James, that day?
Yes.
118.
Thank you. No objection to 118.
I think that voicemail is the most
This is a Facebook message between
exonerating
James and Jennifer Crumbley.
of this.
Correct.
Okay.
Nobody
And then
saw this
Jennifer's
coming.
now in blue.
Correct, yes.
Okay. And what did she write?
She writes, Ethan, tell you what happened today.
And his response?
James' response was, yeah.
And correct me if I'm wrong, but there's no further discussion between the two of them on Facebook Messenger.
No, there's not.
Well, also,
Now, sir, I want to.
sorry, I was,
Did you have a complete thought?
I had lots of thoughts. But like even the way Ethan's responding, it's not something, it just sounds like a kid that got caught, like, oh, I just, you know what I mean? Like he's not
Yeah.
responding in a way like he's a psychopath and he's
He
just
responds
well,
like my son does, and sometimes
Yeah,
I'll
like
tease
a
him.
child.
I'll text him. I was like, I'll say something like, "What did you do now?" He's like, "What? Why? What? What's going on?" I was like, "I just got a call from your school," and he's like, he's all freaking out because I'm just messing with him. Right? I get a call from the school that said, hey, we had to talk with him about whatever. He's not in trouble, but I just wanted to let you know. But he'll freak out about it, think he's going to get in trouble. I'm like, no, you're fine. But then I'll mess with them a little bit, and this could be their dynamic.
Yeah, and
Everything that I say is dripping in sarcasm, so it comes across in my text when I read them to myself. But if someone else was to read them, say this particular prosecutor, who knows how they're going to interpret it. But I
he's
say
not
that
very
because
funny.
the school is clearly sending off signals that they're not worried. Like, this is no big deal. This is completely normal. Have a great holiday. Call us if you have a question. He's not in trouble, they specifically said. So
Yeah, he didn't even
take you back
have to go home. No, he didn't even have to go home. I was just saying that.
Well, even the next day when they all met, he didn't have to go home.
The day of the shooting, November the 30th, 2021, And what we'll do is go step by step with what you were able to discern from your available sources of information.
Okay.
How far behind are we? Oh, we're 25 minutes behind. We're not even going to
119.
get a lunch break.
First of all, we already talked about how you were the individual who went through all the surveillance.
I want to speed it up a
videos.
touch. If it's
Right.
too fast, let me know.
Your responsibility to put together that timeline.
Correct.
And did you also put together the timeline when the school shooter was dropped off at school?
Yes.
Okay. He was dropped off at 7:46 a.m. on November 30th?
That's correct.
Any objection to this?
No objection.
119.
I might not be there, Stray, if we don't get a lunch break. I told Eric that depending on how the lunch break goes. This is a new video. I haven't seen this video.
I'm not yelling. Am I yelling?
Who's yelling? Who says you're
Kayla
yelling?
yelled at me. Stop yelling.
Do you see him being dropped off?
Yes. It's him with the gray hoodie and a black t-shirt on.
Right there?
Correct.
Judge, in looking at the time, this might be a good time to break for lunch, given the fact that we're starting to go through the evidence from the day of the shooting.
If your lunch is ready.
Oh my God, I've had the wrong banner up the whole time. Why didn't anybody tell me?
It's a transition. Oh, okay.
I didn't even notice.
So unprofessional. So unprofessional.
I want to let you know that because you're on the stand right now, you're not allowed to discuss your testimony with anyone until you're finished testifying, okay?
We'll do it
Oh, I'm sorry,
live.
ma'am. I apologize. I apologize. Yes,
I need to wake
ma'am.
you
No,
up.
I'm awake, ma'am. I'm sorry.
All right.
I was thinking.
We're in the middle, don't do that. We're in the middle of your testimony, so you can't discuss your testimony.
Absolutely. Yes, ma'am.
Okay,
You
can't
can't eat lunch.
You can eat lunch. You can eat lunch. Okay, thanks. All right. So you can step down.
Oh, there was a
All right,
banner.
So, if we come back to quarter to one, that's enough time, right? So your lunch is ready and.
I have to go and edit and put a new banner over this. All right. So we are done. It looks like we were 25 minutes behind, but then we get into this. So, ladies, what are your thoughts thus far? The poll currently is are these text messages making the defendant look more guilty? Yes or no? 75% so far have said no. There's only been 171 votes, though, of 338 that are watching. So you guys got to go get there and vote. I will also say, I'm going to shut this down. I don't like doing the long streams where I just kill time for an hour. I want to go get something to eat. I'll start an afternoon stream up. When this ends, if you have redirect automatically set up, you will automatically go to the new stream. If not, what I will do is pin the link to the new stream right now in chat. And then when you get over to the new stream, you can hit notification and then you'll get notified when I go live again for the afternoon, which it should be around 1:10, 1:15 or so, maybe 1:30. And we will we'll go live when the court comes back. But in the meantime, on the other stream, pinned at the top of the chat, is a link to Laid Back Law, which is Eric Hunley's channel. There's a panel of attorneys that talk about various things in law that's going on. We got Nate the lawyer, Joe from Good Logic, yours truly, Sean, potentially criminal, Ian, Southern Law, and it looks like Danny on Direct are all going to be on the panels today. So we'll see I don't know what the topics are, but he wanted me to come give an update on this case. So I'm going to do that for a little bit. But ladies, what do you think?
I'm just taking this all in. It's a lot.
Fair enough.
Yeah.
Jamie?
I've been very vocal about how I feel about this. I just think, I don't know.
It is frustrating.
It
You
is
know,
frustrating.
Yeah. It is very
'Cause I
frustrating.
don't think this should be criminal. And I'm just so frustrated with the kind of stuff they're bringing in. The text messages just going on and on and on with like these situations where it's like, oh, what do you like? Yeah, I don't know.
Taking it all in here. No, I feel like that's good. Well, you're accepting it like a jury, right? I know, Danielle, you are very new to this case. I don't think you've been following a lot of it.
No.
So I like having your perspective on this because I've been watching this case for the last 2 years, and I kind of want to know what your thoughts are. Lisa, I love that you love this channel. Thank you very much.
And X-Comer, maybe just have Danielle and Jamie on panel.
You know what? That's fine. That's fine. I'll remove myself for the afternoon stream. It'll just be you two. I'll give Danielle controls because Jamie doesn't want them.
I don't.
All right. Well, thank you all. I will see if Jamie and Danielle want to join me back for this afternoon. I'll send them both links shortly. In the meantime, I'm going to grab something to eat real quick and then jump over on Laid Back Law. And we'll see you guys
Have
this
fun.
afternoon. All right.
See
Bye,
ya.
guys.
Bye.
When I was young, my daddy said, gotta keep one eye